List number 1, serial number 21. Respondents, 2 weeks may be granted. And March. Huh? 21. List number. List number 1, serial number.
Wait, sir. Please wait. Have patience.
Can it bring the memo on Friday? It is listed today. It is not listed that the memo there is an urgency in this matter. Because
When do you want it? When do you want it?
today itself.
What is the urgency?
Urgency because the evidence will be taken up tomorrow onwards, and the lady, the respondent is treating the petitioner very cruelly. That is the reason why there is
All right, listed in the afternoon.
Adjournments page wise. Page 1, list 1, serial number 1 to 3. Page 3, serial number 4 and 5. Page 4, 6 to 10.
My lord, serial number 9, my lords.
Yes.
Appear for the appellant in this case, my lord.
Hmm.
Insurance company appeal, my lord, on ground of liability. I pay for 2 weeks' time, my lord, in this case.
Your appellant.
I'm for the appellant, my lord.
At request of appellant, call after 2 weeks.
TCR may be required, my lord. TCR may be required for this.
File registry to secure TCR.
That's number 10.
Yes.
Direction was given and the copy is served on me, my lord. I have received it yesterday. 2 weeks time given and file wakalat, my lord.
All right. Learned counsel for respondent number 2 acknowledges the receipt of copy of appeal memo. Call this matter after 2 weeks at his request.
Much.
Page 5, serial number 11 to 18.
Lord, serial number 12, my lord. I am for the appellant.
Hmm.
Lord, pray for 2 weeks time, my lord.
Request of appellant, call after 2 weeks.
The meanwhile, my lord, TCR, my lord.
Security XCR in the meanwhile.
My lord, serial number 13, my lord. Press 2 weeks time, my lord.
Request of appellant, call after 2 weeks.
TCR may kindly be called for respondent.
Death case TCR. Is it required?
Wait,
Death case ಏನಿದೆ ಯಾರ್?
Driver, but is
Security CR. You are not in appeal.
no,
It's an appeal by the claimant.
yes, miss.
Yes.
Page number 6, serial number 19 to 26.
Serial number 26, my lord. Appearing for the respondent number 1 and 2.
I am for
Read
appellant, my
for 2
lord.
weeks time. Serial number 26.
You-
In connected matter, cross objector navis.
Huh.
Press for 2 weeks time.
Learned counsel for the claimant seeks time. Call after 2 weeks.
Serial number 21.
Yes.
2 weeks time. Respondent.
Request of counsel.
20.
My lord, I represent the petitioner, my lord. My lord, ಎರಡು ಸರಿ time ಕೊಡು, date may kindly be fixed, my lord.
21 ಅಲ್ಲ.
ಹೌದು.
All right. Call this matter on date ಕೊಡಿ.
20th February, sir.
20ನೇ ತಾರೀಕು 20th.
18.
Please, my lord.
20th, 21, 20. sir.
24.
You want on 18th?
18.
All right, we'll have it on 18th.
Much obliged.
Much.
Lord, serial number 24. I am representing Ravi S. Samprati, my lord.
Hmm.
For Silvan, week accommodation.
I am for appellant submit, date fix ಆಗಲಿ ಸುಮ್ಮನೆ.
Request of a respondent 1, call this matter
Number
on
8 to 12,
19 February.
number 13 to 15, page 5, number 16 to 19, page 6, number 12.
Take 2 months.
Hmm.
Page number 7, serial number 27 to 31.
My lord, serial number 27, my, I am for appellant. I pay 2 weeks accommodation. I already informed you.
I am for appellant, my lord. Connected matter.
Learned counsel for the claimant
Claimant.
seeks time. Call after 2 weeks.
Please, my lord.
Page number 8, serial number 32 to 37. List 3 adjournments, if any.
Serial number 4, my lord. List 3. And for
Serial number
respondent,
1, my lord.
How to file objection. Respondent number 2.
Serial number
4, my lord.
4.
List 3.
You are for R2.
R2.
Bhimaya.
ಯಾವ್ದು 12, 12, 14.
Learned counsel for respondent number 2 seeks time.
ಹೇಳಿ.
Call this matter after 2 weeks.
ಮತ್ತೊಮ್ಮೆ.
12, 14 and 15, my lord.
2 others. 12?
12, 14, 15.
Huh.
Up 2 weeks after that.
12, 14 and 15 at request of counsel for the insurance company. Call after 2 weeks.
Serial number 3 also.
Serial number 1.
Next week.
3 also. Learned counsel for the insurance company seeks time. Call after 2 weeks.
Serial number 1, my lord.
Yes,
May kindly be taken up on some other day, my lord,
all right. Request
to
of
produce the
counsel
proof.
for respondent.
Yes,
Call after- Yes, date could be
12th February.
12th. What is left now in this? All right.
Serial number 2. 5 to 11.
My lord, list number 1, serial number 4, my lord. My name is H.C. Betsur as shown for the insurance company. My lord, this matter is not interested to me, so your lordship direct the office to delete the name of H.C. Betsur in MFA 5830 of 21.
Which insurance company? Which insurance company is yours?
Reliance.
Who appears for Reliance?
Reliance General.
Reliance ಗೆ ಯಾರು appear ಆಗ್ತಾರೆ? ಪಾಟೀಲ.
Ashok and Patel.
Registry to show the name of learned counsel Sri Ashok N. Patil for R2 and delete the name of learned counsel H.C. Betsur from the cost list. Call after a week.
Much okay.
List one, for admission, seal number one, R Lakshmana.
Appear for the respondent for appellant.
My lord, it is a case of injury, my lord. Sustained a head injury, right front temporal parietal acute subdural hematoma and diffuse cerebral edema, fracture, omer on both bones of a nasal bone. My lord, kindly, here is the issue number 2, my lord. Para 17 of the judgment, my lord. My lord, middle of the line, exhibit P6, wound certificate, reveals that he had sustained post traumatic head injury with right FTP acute SDH post craniotomy status. Further, it reveals that at the time of accident, he was aged about 32 years. He was an inpatient for a period of 3 days. Further, the petitioner also produced discharge summary exhibit P8 issued Navachetan Hospital, Bangalore, reveals that the petitioner admitted to 12/6/2018 to 18 and discharged on 19/6/2019 was diagnosed severe diffuse actionable injury. Further, exhibit P6 reveals that the injury number 1 is grievous, injury number 2 and 3 are simple in nature. In addition to this, petitioner made an attempt to examine other independent witness, exhibit PW2 and 3. PW2 is either working as a neuro rehabilitation and MLC consultant and the Neuro Rehabilitation Center, Bangalore. Is consultant neurosurgeon at Deepashri Hospital, Bangalore, stated that the petitioner sustained head injury with facial and had LOC, loss of conscious GCS, and CT brain reveals that SDH in right frontoparietal region with midline shift is seen to left side and fracture bilateral muscle bones. Further deposed that PW1 has difficulty unable to walk, unable to bend the neck, difficulty in explores sunlight. A patient is conscious oriented who social interaction and social inhabitation. Further, he obtained neurological report given by Aparna Mahesh and has given 33.3% disability to the whole body. He has produced exhibit P17 to 19 recent examination report, neuropsychological report and CT scan report respectively. In the cross examination, he has admitted that the petitioner had sustained grievous injury on his head and face, and the said injury was due to the road traffic accident. Further, also stated that a petitioner can do his professional work as earlier. Cannot do his professional work as earlier he was doing before he met with an accident. Exhibit P8 is the discharge summary discloses that for these injuries he has taken treatment inpatient for a period 3 days in Navachetan Hospital. Further, a petitioner stated that owing to accidental injury he has become permanently disabled and lost the earning capacity. PW2 has stated in his evidence that he did clinical examination and found that the petitioner's breathing difficulty, unable to bend neck, difficulty in exposure to sunlight, patient is conscious oriented, poor social interaction and social inhabitation. He is depressed, not able to work presently. He has operated neuropsychological assessment, has assessed the disability at 33% to the whole body, my lord. So the tribunal is considered only 15%, my lord. 15%. And the income is 11,000, my lord.
Age is 31, is it?
32, my lord. At the time of accident, my lord, he was working as a restaurant manager, earning rupees 79,276, my lord.
All right. What is produced? So that is taken, income is taken actual?
11,000, my lord. 11,000.
You say you're working earning 79,000.
Yes, my lord.
No document produced.
Produce, my lord. Exhibit P12, PWM has produced appointment letter as per exhibit P12, reveals that he was joined to serve 15/5/2013. In the said company was drawing 60,000 per month. Exhibit P13 is the form number 16 issued by Olive Bar and Kitchen Private Limited Company. From this document, it can be said that PW1 is the income tax assessee. Exhibit P14 is the relieving letter dated 13/9/2012 issued by the NB Enterprises Private Limited, reveals that PW was diagnosed as restaurant manager, worked in the F&B service department from 5th to 2010 to 12th September 2012. It pertains to note that the accident took place on 4/6/2018, but he relieved from service on 39/2012 as per exhibit P14. Thus, it is clear that as on the date of action, he was not in service at NB Enterprises Private Limited Company. Therefore, the version of PW1, he was working as a restaurant manager, earning rupees 79,276. Cannot be considered at all. Further, it must be noted that in order to prove his avocation and income, as on the date of action, no document is produced. Therefore, the notional income is rupees 11,000 is taken. Earlier document is produced, my lord. At the time, earlier document is produced.
What were you doing from 2012 to 2018?
Restaurant manager, man.
That is the material.
Yes, ma'am.
ಏನಿದೆ ರೀ document?
Exhibit P12, my lord.
That is till 2012.
Yes,
ಅದರಾದ್ಮೇಲೆ 2018 ತನಕ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್
ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿ.
ಯಾಕೆ? Was he working at all?
No, my lord.
No,
No,
he was not working.
working.
ನಾನು ಹೇಳಿದ ಅರ್ಥ ಆಯ್ತಾ ನಿಮ್ಗೆ?
ಅರ್ಥ ಆಯ್ತು ಸ್ವಾಮಿ. ಯಾಕೆಂದ್ರೆ ಅವರು ಬಾಂಬೆಲ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು, ಆಮೇಲೆ ಇಲ್ಲಿಗೆ ಬಂದ್ರು, ಮತ್ತೆ ಕೆಲಸ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಷ್ಟೊತ್ತಿಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತು. ಆಕ್ಸಿಡೆಂಟ್ ಆಗೋ ಟೈಮಲ್ಲಿ ಅದಕ್ಕಿಂತ ಬಿಫೋರ್ ಮಾಡ್ತಿದ್ದೆ ಅಂತಾರೆ. ಆಮೇಲೆ ಅವರು
2012 ಇಂದ 18 ತನಕ he has not worked.
he was working.
ಎಲ್ಲಿ?
ಬಾಂಬೆಯಲ್ಲಿ ಇದ್ರು. After that, he is not produced any document.
You produce now?
Kindly permit me to 1 week time ಕೊಡಿ ಸರ್.
ಏನ್ರಿ 79,000 manager is working and the court has given 11,000. Is it not your duty to do some justice to your client? You come and sustain whatever your counsel has argued before the tribunal. What is the advocacy you are doing? Your argument is going to fetch him, sir.
Yes, sir.
And he is now, according to you, incapacitated. He cannot work. Is there any material produced by them?
No, my lord.
Notional income is taken. I'll give you 1 week time.
Yes,
Go and produce. Bring the document.
yes, sir.
Even if there is no income, at least some amount which is coming to the bank account, if you produce some document, that can be taken. As a counsel, you know what is going to be the outcome
Yes,
if
sir.
you produce.
But,
Is it not your duty to advise your client? Request of appellant, call after a week. 1 week is enough for you?
yes, sir, 1 week.
ಏನ್ರಿ ಇಷ್ಟು ಕೇಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋ ಗೊತ್ತಿಲ್ವಾ ಏನ್ ಬೇಕು ಅಂತ MFA ಕೇಸಲ್ಲಿ? Where is
Claimant appeal
Chandrasekhar?
for enhancement.
Huh?
Claimant appeal for enhancement, my lord.
You are ready?
I am ready.
Where is Chandrasekharayya? Pass over ಮಾಡೋಣ.
ಮಾಡಿ ಸರ್,
Pass over.
please.
ಶಿವಣ್ಣಗೌಡ.
Appellant. ಇವರಲ್ಲಿ ಇಲ್ವಲ್ಲ?
3.8 and 3.9.
8 and 9.
ಡಿ ವಿಜಯ್ ಕುಮಾರ್ ಬರ್ಬೇಕು, ಇವ್ರು ಬರ್ಬೇಕು, ದಬಾಳಿ ಅವರು.
ಇದೇನು KSRTC ಬಸ್ಸಾ?
Please.
Yes,
There are 2 vehicles involved in the accident, tempo traveler as well as the KSRTC bus. Charge sheet was filed against the KSRTC bus based on the evidence and the evidence given by the eyewitness to the accident.
without
So
consent.
Aragya Gowda appears for claimant.
Please.
He is appearing for the claimant.
Mr. Varatharajan, you are
Claimant.
claimant. So
The
appeal
body-
by the insurance company
Please,
and appeal by the claimants.
please.
Corporation is not in appeal,
They have satisfied the award.
satisfied the award.
Oh,
So what is the
50-50 was,
liability?
50-50 was the negligence was apportioning. That I have challenged before your lordship. They have satisfied their work.
So only thing is whether you are liable for the 50 and
Please.
whether claimants are entitled to enhance.
Any addition,
All right, Madi, argue.
please.
Who appears for the corporation?
The
Bali.
body our work,
All right. But anyway, he is not disputing the liability.
there is no dispute, only apportionment whether,
He may oppose to you the entire liability fixed on.
Liability.
Then why then let him come?
that's all. May I submit?
Yes, yes.
Right on 11/5/2017. The petitioners were traveling in our insured tempo traveler. Bearing number KA05 AF 9869. While they were proceeding towards Vastu Road, Melad, the bus bearing number, KSRTC bus bearing number KA40F 371, which was driven by his driver, was parked the lorry on the middle of the road without any indication. That it is in the evening, the accident was occurred. But as per the petitioner, all the petitioners, they given the statement before the police as well as they have given the evidence before the MSCT, where they say that Malad, the place of accident at 7:30 PM, there was a door. And there is some curve also. The driver of the tempo traveler, when he reached near that bus was parked, he has applied the brake. But
Which road was it?
Panvala,
What road is it?
it is highway,
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
please. Vasur highway, road,
NH7 road.
please.
Yes.
Dashed against the in portion of the bus. And because of that reason, Malad, there were the petitioner who was traveling in our insured vehicle sustained injury.
So all the claimants are traveling in the tempo
Tempo,
because the bus was stationed
please. Parked.
Parked. in breakdown agite. Breakdown.
According to them, it is big. Malad, the complaint was lodged against the driver of the bus. The investigation officer was investigate the matter and filed the charge sheet against the driver of the KSRTC bus. The entire evidence of the petitioner, allegation against the driver of the bus who was abruptly parked the vehicle in the middle of the road without any indication. Therefore, the accident was taken.
So FIR charge sheet, everything on
All
the
documents.
bus. Nothing against you.
Bus, please. And the driver of the bus was given the evidence before the court in the during the cross examination. Yes, accepted that Malad. He has not challenged the charge sheet before any of the court. Therefore, the charge
He
sheet,
is convicted.
please.
Convicted?
No, criminal court is concerned, Malad. I'm not aware of what has happened, Malad. He has admitted that, Malad. He has not challenged that charge sheet in any of the court. Therefore, my respect submission, parking of the bus in the middle of the road itself, is it the negligence on the part of the driver of the bus? Malad, the apex court and occasional the ACJ 2018 AER page 2118, wherein Malad Nishant Singh versus National Insurance Company, where the the parking of the bus, parking of the vehicle in the middle of the road, obstructing the on to the bypass itself is the sole negligence to cause the accident. Therefore, in that case, madam, the entire negligence was attributed against the vehicle which was parked on the lorry which was parked on the middle of the road. Therefore, my respect submission in this case, madam, the tribunal has fixed the liability, the negligence against the insurance company to the extent of 50%. Therefore, I am before your lordship that is in perverse. Considering the evidence on record and the document placed before the court below ought to have dismissed the claim petition against us, but it is not held. Therefore, I am before your lordship. The finding given by the court below regarding that, my lord,
So it is not in dispute that it was parked in the middle of the road
there is no dispute.
by KSRTC,
No,
admitted.
it is an admitted fact.
Sketch and other things also proves the same.
Please.
ಇಲ್ಲ, ಅವ್ರು ದಬಾಲಿ phone ಮಾಡ್ರಿ.
Or ಅದಕ್ಕೆ ಅವ್ರು ಬರ್ಬೇಕು ಯಾಕಂದ್ರೆ he is the
May
contestant.
come some, who has the phone number?
He will
Immediately,
definitely,
Nayak, you have Dabali's phone number. Call him outside. That is the only argument.
please. On 2 cases ಅಲ್ಲಿ compensation grant ಮಾಡಿರೋದು ಜಾಸ್ತಿ ಇದೆ ಅಂತ my appeal, not only purely on the negligence aspect, my appeal is basing.
So the judgment which you relied of Nishan
Please,
does not attribute any contributory negligence on the other vehicle.
no. Entire negligence has attributed on the parked lorry.
Our negligence ಇದೆ, but
Please.
why you could not see that and stop it or slow down?
That's what, my lord. In a public highway, public road, my lord, nobody is authorized to park the vehicle. But that vehicle was parked in that place due to a mechanical defect.
Which is that rule which says so?
Pardon, my lord?
Which is the rule which says?
Rule 28 of the Road Regulation Act, my lord. No.
Where is that?
I will place it, my lord. No.
Motor vehicle rules, central and Karnataka motor vehicle rules also is there. Central motor vehicle rules. The rule very
Road-
clearly specifies.
Please, road
Ah,
regulation.
Road regulations. ಮಾರ್ಕ್ ಮಾಡಿ ಇಡ್ಬೇಕಮ್ಮ ನೀವು ಅದರಲ್ಲಿ ರೋಡ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಯಾವುದು ಏನು ಅಂತ.
Kindly pass over the matter, my lord. I will bring that judgment also. So, ಅದರಲ್ಲೇ discussion ಮಾಡಿದ್ದಾರೆ ನಿಶಾಂತ್ ಸಿಂಗ್ ಕೇಸ್.
Yes. You take out.
ಅವ್ರು
mark
ಬರ್ಬೇಕು
it on.
ಅವ್ರು.
That
ಅವ್ರು
is
ಬರ್ದೆ
the-
ನಾವೇನ್
what is
ಮಾಡಕ್ಕಾಗಲ್ಲ.
going on there. Pass over.
Please,
Call-
kindly
bring
pass
it.
over. He will attend, my lord.
Varadaraj and Ranrangegowda will be seeking enhancement.
ಇಲ್ಲ ಇವ್ರದ್ದು ಅಪೀಲ್ ಇದೆ, ನಿಮ್ದು appeal
Only,
ಇದೆ.
my lord, ಇದರಲ್ಲಿ 3 cases ಅಲ್ಲಿ ಮಾತ್ರ small announcement.
ಇಲ್ಲ ಇಲ್ಲ ಇವ್ರದ್ದು
Only with regard to the income ಅಷ್ಟೇ.
ಇದೆಯಾ?
So in your case, it is a case of injury or
My lord, one is 2 cases of injury.
one death case?
Another one death, my lord.
In Mr. Varadarajan's case, it is injury.
ಪ್ಯಾರಸ್ ಒಂದು ಓದ್ಬಿಡ್ತೀನಿ.
ಹಾ, ಕೊಡಿ.
ಪ್ಯಾರಾಗ್ರಾಫ್ 41 ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್.
3.8 ಅಲ್ಲ?
3.8 ನಮ್ಮ ಅಪೀಲು ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
ಇಲ್ಲ ಇಲ್ಲ, 3.8 ನಿಮ್ದಲ್ಲ.
3.8 ಇನ್ಶೂರೆನ್ಸ್
ಹಾ, 9 ಅಲ್ಲಿ ನಿಮ್ದು ಅಪೀಲ್.
if the court holds that the tempo insurance company is not liable, entire liability should be fastened on KSRTC ಅಂತಂದ್ರೆ, then this appeal may not survive. KSRTC has not challenged the as far as the compensation is concerned. So therefore now kindly come to.
So your argument is if this court allows the appeal of Shivannegowda, then his appeal in
Entire
your case
liability
will
will
not.
be on the KSRTC because KSRTC has not challenged the
Correct.
award. Now if the court affirms this judgment, then both are liable for 50-50.
Therefore, so I have no much say in that regard. But so as far as the compensation is concerned, let's kindly come to paragraph 41, internal page 30 of the award. 4 or 5 paras, I just read the kind of the injuries that I have sustained, the kind of the money that I was required to spend and all that. But the petitioner Meenakshi in MVC so and so has contended that in the extent she suffered a lacerated wound below the knee, fracture shaft L femur, contusion, shoulder and arm and pain and other injuries all over the body. In order to prove the nature of the injuries sustained and the treatment taken, petitioner has produced the wound certificate issued by the Best Hospital Chandapura at Exhibit P5, which shows that the petitioner has sustained lacerated wound below the left knee, fracture shaft left so and so, and contusion left shoulder and right arm. And the doctor has opined that the injury number 1 and 3 are simple and injury number 2 is grievous in nature. Exhibit P11 and 12 are the discharge summaries issued by the Bangalore Emergency Surgical and other Best Hospital, Care Hospital, Bangalore, which shows that the petitioner has been treated as an inpatient from 11/5/2017 to 18/5/2017 for fracture shaft femur left lower limb. The discharge summary further discloses that the petitioner had been treated by the closed reduction and internal fixation. The discharge summary at Exhibit P11 issued by the Best Hospital reveals that the petitioner had been treated as an inpatient from 26/6/2017 to 2/7/2017 for dengue fever with enteric fever. The petitioner has also examined PW2, Dr. B.N. Nagaraj, orthopedic surgeon at the SOTS, Bangalore, and the evidence of PW2 insofar as the nature of the injuries sustained by the petitioner, treatment taken, and the period of treatment corroborates with the evidence of PW1. Thus, considering the nature and gravity of the injuries sustained, period and nature of treatment, the petitioner is awarded rupees 40,000 as compensation towards pain and suffering. This is one item where I am contending that it should have been slightly more than what is awarded. The court has the fixed standards for avoiding compensation for pain and suffering. Then in order to prove the amount spent treatment, the petitioner has produced 75 medical bills for rupees 79,406 at Exhibit P9. The EP bill, inpatient bill of Best Hospital is for rupees 27,380 at serial number 72, cannot be taken into consideration for the reason that the petitioner had taken treatment from 26/6/2017 to 2/7/2017 for dengue fever, which is unconnected with the accidental injuries. I don't think I can find any fault with this reasoning. Exhibit P13 is the bill issued Best Hospital for rupees so and so for having treated the petitioner from 11/5/2017 to 18/5/2017, and the remaining medical bills from serial number 1 to 44 are towards purchase of medicines and consumables, and there is nothing on record to disbelieve them. And serial number 75 at Exhibit P9 amounting to rupees 33,127 are accepted as the medical bill from serial number 45 to 72 and 74 are in the respect of purchase of medicines and consumables for the treatment of dengue fever for the period between so and so. Further, the inpatient bill for rupees so and so produced at Exhibit P13, radiological bill for rupees 700 and P15 and 8 medical bills for rupees so and so amounting to rupees 1,07,232 are accepted. Thus in all, the petitioner is entitled to 1,41,359 towards medical expenses. Petitioner has taken inpatient treatment for a period of 8 days while the petitioner was inpatient. Someone must have attended her needs, and further, the petitioner may have incurred some amount for conveyance and food and nourishment.
I don't,
Hence-
that is also correct. Does not call for interference.
Very well. Then, the petitioner claimed that she is aged 43 years and doing agricultural work and earning rupees 20,000 per month. And an account of injuries sustained in the accident, she is suffered a permanent disability. The petitioner has not produced her birth certificate, school certificate to prove that she was aged 43 years at the time of the accident. Though in her cross-examination, she has stated that she has filed documents to show her age. No such documents are forthcoming. Therefore, the court has to look into the available medical and police records on perusal of Exhibit P5 wound certificate at the of the petitioner and Exhibit P14, P4, the charge sheet. In both-
9,000 is the income taken.
both this, the age of the petitioner is shown as 48 years. Hence, for the purposes of this case, the age of the petitioner is taken as 48 years. If my age is 43,
But nothing is produced by you. Even a kodabekala. Even now, if you are having something, you can give, you will agree.
I understand.
So age is 48, income
fort-
is taken at 9,000. That is probably
The-
on the lower side.
The last this thing is housewife ಅಂತ ಹೇಳಿದ್ದಾರೆ. While I have said I am doing agriculture, ಅದು next para. In proof that she was doing agriculture and earning rupees 20,000 per month. The petitioner has produced the RTC at Exhibit P8 and on perusal of the same, it is seen that they are not standing in the name of the petitioner, and the petitioner in her cross-examination has admitted that the RTCs are standing in her husband's name. Would this make much difference, whether it is standing in my name or in my husband's name?
Not make
I
any
am the one who is doing that work.
That will not make any difference.
Further, in the charge sheet in Exhibit P4, the occupation of the petitioner is shown as housewife. Hence, the petitioner is considered as a housewife, and the accident that has occurred in the year 2017, the income of the petitioner is notionally taken as 9,000.
ಎಷ್ಟು
ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಇದಾಗಿದೆ, ಕಮ್ಮಿ ಆಗಿದೆ ಅಂತ.
ಎಷ್ಟು ತಗೊಳ್ಬೇಕು?
That's my. Since the petitioner has suffered the fracture, the left so and so, and has been treated by closed fixation, internal fixation, petitioner, closed reduction and internal fixation, petitioner may have been in a position to, may not have been in a position to work for 3 months, and therefore the petitioner is awarded 27,000 towards loss of income during the laid up period of 3 months at the rate of rupees 9,000 per month. ಅದು notional ತಗೊಂಡು ಅದು ಮಾಡಿದ್ದಾರೆ. But if that is taken as 20,000, so I am entitled to 60,000 rupees on that count. Now, as far as the case of the petitioner that she has suffered a loss of future income on account of the disability is concerned, the petitioner has examined PW2, Dr. Nagaraj, orthopedic surgeon, Swords, Bangalore, and in his affidavit evidence filed in lieu of, so the examination in chief, PW2 has described in detail about the nature of the injuries sustained by the petitioner and the period and nature of treatment given to the petitioner. He has further stated that on 5/1/2018, he examined the petitioner for the complaints of weakness and pain in the left lower limb, unable to sit down, squat and sit cross-legged. And on examination, the petitioner had wasting of high muscles, stiffness in the left knee and restriction in the hip movements. He has stated that there is 38% loss of mobility component, 25% loss of stability component, and by taking the telescopic formula, the loss of the mobility and stability component is 50%, and has added additional points of 5%, and has assessed the total disability of the lower limb at 55% and the whole body at 18%. He has further stated that the petitioner requires to undergo another surgery for removal of the implants, and the estimated cost would be rupees 40,000. In support of his oral evidence, PW2 has produced the clinical report at Exhibit P23, the X-ray film at Exhibit P24. In his cross-examination, the learned counsel for the respondent Number one, PW2 has admitted that he has not given treatment to the petitioner at any point of time, and he has gone through the wound certificate and discharge summary only, and the fracture is united. Thus, considering the fact that PW2 is not the treated doctor, although he is an orthopedic surgeon, and further the fact that the fracture is united and there is no any complications of either malunion or non-union of the fracture. The functional disability of the whole body suffered by the petitioner is taken at 10%. If that is the petitioner is awarded compensation under the head loss of future income on account of disability as and income of the petitioner is taken rupees 9,000, 10% comes to rupees 900. Annually, it comes to 10,800, and the same has to be multiplied by 13 multiplier having regard to the age of the petitioner being 48, and hence the petitioner is awarded 1,40,000 towards loss of future income. Illi I have got some grievance. He may not have treated me, but so he has examined the whole history of the case, and he has given evidence merely because he has not treated me in the first instance. Would that be a ground to discard his evidence? He has given 18% as the disability. Let's arbitrate. Of course, some arbitrariness will always be there, even in the court fixing the 10% this thing. But my respectful submission is it should have been taken at 18% itself, because a surgeon who is expert in these matters has given evidence. His evidence ought not to have been discarded merely because he had not treated the petitioner in the first instance. Then in the next paragraph, the court finds the breakup. Pain and suffering 40,000 ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡಬಹುದಾಗಿತ್ತು ಅಂತ ಹೇಳಿ ನಂದು, that's my honest belief. Then medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. I don't think I can find any. ಇದು conveyance, attendance, food and nourishment charges. Loss of income 27,000. ಅದನ್ನು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ 1,40,400 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ if the court accepts the evidence of that expert surgeon at 18%.
Now, as per PW2, the orthopedic surgeon, the injury suffered is a fracture of the left shaft femur.
As far as the nature of the wounds that I have suffered and the fracture, there is no dispute.
So contusion, left shoulder, right arm, lacerated wound. So that
Below-
is not a serious
Below the
injury.
knee,
So 1 and 3 is not serious, simple.
simple. 3 is the grievous one.
Second, 2 is the grievous one.
2 is the grievous one.
That is a shaft femur.
That's right. Some surgery is done. I was
She is not doing any work outside. She is not doing any work outside home.
Husband and wife, the court takes the rule, this thing. Let's wife works in the field as far as I know.
Works in the field. huh? No, are they-
Agricultural operations.
Agriculturist.
RTC is in the name of the husband anta heli. That's the reason for disbelieving that I am doing agriculture work.
No, that left shaft femur fracture is also united is what the doctor has said. How the doctor has come to the conclusion of 55% to the left lower limb, that itself is on the higher side.
No, but ultimately he has assessed the total liability at 18%.
Yes, that is what is again on the higher side. Because there is only a shaft femur fracture united.
United, but then the implants have to be removed in a future date.
Implants removal is a separate compensation. Disability has to be assessed on the basis of the injury sustained,
That's right.
which is going to be affecting her future earning capacity.
That's right. The court takes it at 10%, doctor
So that can
finds
be
at
marginally increased, but not 18.
at 18%.
All right. Yes, that is all. Only one case timbre ಅದು.
ನಂದು ಒಂದೇ ಅದ್ರಲ್ಲಿ ನಂದರಲ್ಲಿ 3.8 cross appeal saying that this is higher side ಅಂತ.
So what is the notional income to be given in your case?
Let's, I think 15,000 is the notional income anta.
All right. Chart is the chart.
11,000.
Chart is the chart.
Howದು? Rather 11,000, right? 11,000.
So we'll give you 11,000.
Very well. Idu next one,
Disability marginally increase.
10 and 18.
ಅದಕ್ಕೆ ಮಧ್ಯದಲ್ಲಿ ಒಂದು ಕೊಡ್ಬೇಕು ನೀವೇ ಫಿಗರ್. Because she is not a skilled worker, she may be going to the fields to work in the. All right, next. In the.
My lord, in MFA number 2895 of 22.
No, is Mr. Diwali coming now? Oh, he's here.
Sorry.
You are ready to argue?
Yes.
All right. Yes, you can complete.
Please. Idrali. My lord. Appellant has sustained
So the argument.
paragraph 80 of the judgment.
Huh?
Paragraph 80 of the judgment.
ನಿಮ್ದು ಯಾವುದು?
In page number 50,
No, yes, you are arguing now 3.10.
please. 2895 of 22.
Page.
MEC number, my lord, 7589 of 2017.
MVC.
MEC, my lord, 7589 of 2017. Please.
Yes.
My lord, the date of accident, my lord, 11/5/2000.
That you need not come to date of accident.
Please.
Directly come to.
My lord, is sustained, my lord, the compound fracture of right femur.
Paragraph
Paragraph, my lord, 80 of the judgment.
80.
80. Sustained, my lord, the compound fracture right femur with lacerated wound over right thigh, fracture of right patella, fracture of both bones of left forearm. Inpatient for a period of 16 days.
3 fractures.
Please.
Hmm.
16 days, my lord, he was doing
Inpatient for
16 days. She was doing tailoring work, earning 15,000 per month.
age.
Age, my lord, 31 years as on the date of birth.
Now, what is taken by the tribunal?
Tribunal, my lord, considered 31 years. Adopted multiplier, 16. Disability, my lord, considered 25%.
What that is taken by the tribunal or the doctor says?
Tribunal, my lord.
So you are.
Is correct. Only, my lord, income, my lord, considered 9,000 per month.
So that has to be 11,000.
Please. Then, my lord, pain and sufferings is on lower side.
Whether there is.
Tabular column, my lord, 90, paragraph 92 of the judge.
50 ಕೊಟ್ಟಿದ್ದಾರೆ.
Out. That is lower side, my lord. Then, my lord,
Inpatient for 16 days.
please. Suffered, my lord, 3 grievous
All right,
injuries.
medical expense actual,
Actual,
25,000, correct.
correct.
Income during later period will,
Later period also correct.
how many months is given?
My lord, around 6 months. 9,000, 11,000 add ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ
All right, next. Disability.
loss of amenities, my lord, and
Future medical expense,
future medical expenses, my lord, 25,000 has been.
what is stated by the doctor?
Please.
What is stated by the doctor?
Doctor stated, my lord, medical record petitioner are treated as inpatient for implant, removal of implants, my lord, hence awarded 25,000.
Yes. That's all.
That's all.
Next.
Another one, my lord, MFA 2898 of 22 in MEC number 7590 of 2017.
MVC number
7590 of 2017.
which is the paragraph?
Paragraph, my lord, 93.
Ah,
Case of death, my lord, age of the deceased is 69 years as on the date of.
this is a death case.
Please,
Age is 70.
69 years as on the date of first. Tribunal, my lord, considered income, my lord, 9,000. 2017 Act.
The multiplier is 5.
Multiplier is 5. The rates compensation, my lord, 80,000 has been given. Escalatia may be given. And funeral expenses only 15,000. Estate is not given. Loss of estate.
Who are the claimants?
Claimants, my lord, sons, two sons.
Major.
Please,
So what is the loss of estate given?
my lord, loss of estate, my lord, 1,80,000.
What is the basis of calculation?
Basis of calculation, my lord, tribunal taken income of the deceased, my lord, 9,000 per month. And is to workouts to paragraph 98 of the judgment, my lord. One third has been considered. Then, my lord, awarded 1,80,000. Multiplier 5 has been adopted. 1,80,000 is the loss of estate. Paragraph 98 of the judgment.
How much is deducted?
One third.
1/3.
That is correct.
That is correct.
Correct.
Now 1/3 has been awarded.
That he sustains that. You have to say whether it is. He'll sustain it. You may have to dispute it. Are you in appeal in that case?
They are satisfied the trial court.
You are not in appeal in that, this
No, we
case.
are not. Insurance appeal is there.
Huh?
Insurance appeal is there.
Or Shivanna Gowda. Nimdilla.
They are satisfied.
No, but if this court agrees with Shivanna Gowda and fixes the liability on you, then there is no challenge to his appeal by you.
About negligence matter, I will.
No, I will hear you.
Oh, yes.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ 2921 of MFA.
What is this parental consortium? That is for two of them, are there?
Please, please,
Two,
please.
2 or 3?
Two.
All right. The only thing is the income has to be increased.
That's all. Then, my lord, one more case. 2921 of 22.
Two nine.
2921 of 22.
3.12. What is that MVC?
MEC, my lord, 7591 of 17.
Page?
Page, my lord, 64 of the judgment. Paragraph 103. Suffered, my lord, the right fourth rib fracture and head injury, and both are grievous injuries.
Which is the paragraph?
Paragraph 103 of the judgment.
Yes. This is an injury case.
My lord,
Injury.
please.
Yes.
My lord, global compensation, my lord. In this case, my lord, admittedly, doctor has not been examined. Global compensation only 25,000 has been,
25,000.
please.
No evidence.
No, evidence. Doctor not.
Doctor evidence ಆಗಿದೆ.
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
Fracture of fourth rib.
Medical expenses, my lord, around 3,917.
What is the rib fracture and head injury?
Please,
Fracture of fourth rib. Fracture of fourth rib.
fracture of fourth rib and 18.
What is the amount granted here?
25,000 is the global compensation.
ಏನು ಮಾಡಿಲ್ಲಲ್ಲ ಎವಿಡೆನ್ಸ್.
Please.
What is the age?
Age, my lord, 60 years.
He is agriculture. What was she doing?
My lord, she is doing cooling. In other cases, my lord, compensation awarded is just and reasonable.
In other cases.
Outfit.
Other cases just and reasonable andre in which you are not challenged, is it?
Please,
So you are replying to Shivarna Gowda's argument.
please.
But he's only on, not on that aspect. He's only on the aspect of shifting the
What the
liability
negligence,
to the corporation.
please,
He's not questioning the,
please. Much
yes, Mr. Dabali. You have heard the argument. You are not here when he argued.
I was head of.
Huh?
I was head of in portal number.
His argument is that you have parked the bus in the middle of the road.
Because of breakdown of the bus.
So his argument, you park the bus in the middle of the road, entire liability to be shifted on the bus. And he relies on a judgment of the Supreme Court. And which is that motor vehicle rules 28,
50.
15. The,
28 is also distance.
no, 15 is the correct rule.
Parking on the prohibited.
Did you take out from our?
That is parking of the vehicle, not because of breakdown of the machinery of the vehicle.
Parking.
Whether parking or breakdown.
Here, but it was breakdown of, because of.
No, have you informed?
Yes, but
After the breakdown, did you?
yes,
inform?
it was taken, attention has been taken. It was parking, my lord, it can't be applied.
1510. Subclass 10, next page,
Yes,
where parking prohibited.
yes, what is your argument?
That is general rules, my lord, it can't be applied because here, but the breakdown of the machinery, the joint, my lord, of the. Both negligence.
When did the accident take place?
On 11/5/2017,
What is the time, sir?
7:30.
7:30 PM.
PM.
Yes, madam.
When did your vehicle break down?
During evening time,
When did your vehicle break down?
just 10-15 minutes earlier,
Where's the evidence?
10-15 minutes earlier.
10-15
There is
minutes.
no exact timing has been stated,
No, what is the measures you have taken to prevent any?
but here, madam, because of breakdown of the machinery, madam, the bus was halted. And other vehicles are moving, madam, on the left side of the bus. But this man, madam, the tempo, madam, came from behind and dashed, madam, due to the impact, madam, the entire front portion of the tempo tower has been damaged.
No,
As
what
per-
is the measure you have taken to show any signal or mark or sign that your vehicle is broken down?
And there is the evidence, madam, of the driver.
What have
It
you?
has been considered by the tribunal, where
Yes.
even para Internal page 22 murder. Para 28, one of the inmate of the,
Para?
para 28, murder, internal page 22 of the judgment. Type page 22 of the judgment, murder, para 28. This is one of the injured person murder, Yellappa.
28.
Para 28.
Ah.
Yellappa, the petitioner in MVC, so and so, it is cross-examination by the Royal Council for the respondent number 1. Has stated that KSRC was parked on the road due to the mechanical defect and the tipper trailer dashed against the hind portion of the bus. He denied that one person was standing behind the bus. That is the evidence of one of the inmate of the tempo traveler. Then what about consideration?
Now, who is this Yellappa? He is one of the
inmate
petitioners.
one of the
injured-
petition-
injured man, one of the claimant who was traveling in the tempo traveler.
He denied.
No, it was the breakdown of bus murder, breakdown of machinery.
Huh?
There was breakdown of the, due to breakdown of the machinery murder, the bus was parked.
Breakdown is not in dispute.
Yes.
So you don't have to argue on that.
Yes.
You have to argue whether you have shown any sign and signal.
Yeah, but then no.
That is denied by him. I thought he has admitted you are.
RW1 murder has been examined. There are 34 murder. There are 34. Internal page 25 murder. Driver has been examined. Driver and IVO also has been examined. But it is not as if murder accident took place in the midnight or in the highway murder far away from the city. It is a city limit murder. The other vehicles were moving murder by the side of the bus only. Only this tempo trailer murder came from behind and in high speed and dashed murder because of losing balance. Because other vehicles were, it was a busy road, but Hosur, Bangalore road is a busy road.
It is a national highway.
Oh, yes, man. Busy road, but during time.
NHL.
Yes, man. Vehicle will move murder one after the other. Because other vehicles were moving murder by the side of the bus only.
All right, other vehicles have moved. Is that absolves your liability?
No, not completely absorption.
And then?
Because they,
Others have noticed probably. He could not notice.
no, because the vehicles murder, Hosur
Sir,
road.
for other vehicles to go away from the bus to the left or to the right.
Yeah, it was parked in the middle of the road, that's the side of the road divider because of.
Is the signage you have put?
Yes, ma'am.
ಏನ್ signal ಏನ್ ತೋರಿಸಿದ್ರಿ?
ಹೇಳಿದ್ರು para 34 of the judgment murder.
Please read it.
Internal page 25 murder. Internal page 25 of the judgment, para 34 murder, the evidence of driver. On the other hand, the respondent number 1 had examined the driver of KSRTC bus as RW1 and in his affidavit evidence filed in lieu of his examination in chief, RW1 has reiterated the contents of the statement of objections filed to the main petition regarding negligence on his part for the accident and attributed total negligence to the driver of the tempo traveler. He stated that he informed the incident to the ambulance and got admitted the injured to hospital through the ambulance. In his cross-examination by the Royal Council for the petitioners, RW1 stated that he had parked the bus close to the median situated at the center of the road, and the accident took place on Bangalore-Hosur Road, which is a busy road. He stated that he had gone to Surya City Police Station on the same day in the night, 11 p.m. to lodge the complaint. In para 26 murder, RW1 stated that joint itself got cut and therefore he could not move the bus, and he denied that he had parked the bus negligently in the center of the road, and also denied that the accident had occurred solely due to his fault and the driver of the PT is not at fault. The respondent number 3 has also adduced that is insurance appeal, insurance evidence. Then but I will not, there are 38.
Yes.
About conclusion, but I will have also examined by as RW3, there are 38 model.
Hmm.
The response number 3 some. The driver of the bus also model has lost the complaint through speed post. There are 13 in his cross-examination by Legal Counsel for the respond number 1. RW3 stated that he does not know whether the KSRTC bus had broken down. He stated that TT had headlights. He denied that the KSRTC bus had been parked on the left side of the road due to joint cut, and the driver of the bus had taken all precautions by putting stone around the bus. Also, there was indication the backside of the bus and tree branches had been placed on the hind portion of the bus, and denied that he has prepared a false spot sketch and spot measure. He stated that he came to know that KSRTC bus driver had given complaint to the superintendent of police, and his given reply to the superintendent of police that already FIR has been registered as the KSRTC bus driver. On perusal of FIR and complaint, it is seen that complainant one Manjunath has given the said complaint in the police station on the following morning at 9 a.m., attributing negligence on the part of the KSRTC bus driver, as he had parked the bus on the national highway without any indicator and without any signal. The evidence of RW1, the driver of KSRTC bus, Exhibit R1, the complaint given by him, and Exhibit R3 log sheet disclosed that due to the joint cut, the KSRTC bus had got stopped on Bangalore-Hosur National Highway at about 7:10 p.m. The accident melody is at 7:30 p.m. When the KSRTC bus was on its scheduled route, the spot measure and spot sketch reveals that the said road is about 32 feet wide on one side and a straight road with center median. The impact between the two vehicles is at a right side of the road, about 1 to 2 feet from the center median, and there was still sufficient space to the left side of the KSRTC bus. There is no dispute about the KSRTC bus having broken down on its scheduled route. The IME report discloses that the headlights, front bumper, bonnet, top, head, front windscreen glass, front both wheels, mudguard, dashboard, front both doors, and radiator of the tempo trailer had got damaged, and tempo driver Ramesh and other petitioner who were traveling the tempo sustained serious injuries, and driver Ramesh and other traveler by name Rajan succumbed to the injury. The damage caused to the tempo traveler and the driver of the tempo traveler and others succumbing to the injuries sustained by them clearly speaks for themselves that at the time of accident, the driver of the tempo traveler was driving the tempo traveler rashly and negligently and in high speed. The evidence of RW3 IO reveals that the tempo traveler was having headlights, and as per the spot sketch, there was sufficient space on the left side of the KSRTC bus for the driver of the tempo
The judgment which you
to proceed.
Wrong number quote ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. I will place it tomorrow, number.
Yes.
But there is a judgment by Justice Naziz Saab and another companion judges are written the judgment. Parking of the lorry on the middle of the road itself is a negligence.
Yes, but that cannot be entire 100% negligence.
No, but correct, my lord. If they are given the signal and all, absolutely correct. But in this case, my lord, no precaution was taken as admitted by them.
On
Therefore-
that day, apart from your vehicle, any other vehicle has hit the bus?
No.
No, but my lord, what will happen in the national highway, lane will be there. I have to follow the lane. I cannot go this side or that side unless given the signal.
The fact that no other vehicle has gone and dashed him except your vehicle
Yes,
shows.
there is no.
Shows that your vehicle was in a very high speed. No doubt it is a national highway.
Yes, it is.
There has to be contributory negligence against your client.
But not to the extent of this.
May
my
not
lord,
be 50%, that we will decide.
to that extent.
Anything else?
That's all.
By considering not the nature of damage sustained by the tempo traveler, because the entire front portion has been damaged and driver himself has died. That shows what the impact, what the speed of the tempo traveler.
All right, you have to only answer whether you have shown any signs, signal.
The driver has stated this fact more about taking precaution,
What precaution?
about
Where is that?
evidence of RW1 murder.
He has said he has not given any signal. He has admitted that.
No, RW1 evidence murder.
No indication was put.
Where is it, sir? Please read it.
All in evidence of RW1 murder, the complaint given by him, exhibit R1.
Huh?
May I request murder, exhibit RW1's evidence murder.
Read it. Put your RW1 evidence. Put. Read sometime back RW1.
Para 36, he has admitted the RW1, the evidence, he said that man, he has not put any indication, he has not given any
Read para 36.
indication.
If that is the finding is wrong, then read your evidence to show what you have done. Mr. Dabali,
Yes, Lord.
according to you, RW1. Yellappa Harakuni. He is the driver?
Mahadeva problem.
Mahadevappa Yellappa.
Yes.
Who's he?
He is the driver of the
Bus.
bus.
Has he said anywhere that he has put any signal?
I got down from the bus, taken all precaution to put the stone around the bus, also put the indicator backside of our bus, also put the tree green branches to hind portion of the bus on the norms of all the traffic rules and regulations, and also holding the green branches in my hand, showing other vehicles not to touch of our bus. That one report traveler bearing registration about so and so, RW1 murder evidence, chief examination. Second page.
No, this evidence of yours is not supported by the IO RW2.
Because what the accident took place on 11/5/2017 at 7:30 PM. The complaint came to the last one next day, morning 9 AM. The spot mother and other documents have been prepared.
Who was given the complaint?
The one of the inmate of the tempo traveler. He is not the claimant.
No, but have you lodged the complaint to the highway authority?
Yes, madam.
Have you?
Exhibit R1 murder.
When?
On next day, murder. Written complaint was lodged because
When did you lodge that?
by post, murder. It was sent by the post,
Yaru?
by the driver.
Yavaga?
On exhibit R1 murder. Because I was also admitted, I had lodged the complaint and SP has forwarded the complaint to
You are
the.
admitted.
Yes, ma'am.
Right.
It was forwarded to the, because complaint was lodged to the SP. He referred to the.
So what you did after that 7:10 PM when the vehicle broke down?
Yes.
Till the occurrence of that accident at 7:30.
7:30.
Between this time, did you lodge a complaint?
No,
Then?
he stated that when he went to the police station, but they have not received the complaint.
Anybody can say after the accident.
But he has lodged the written complaint, not by post, he has sent the post by post, but the speed post.
The next day, sir.
Yeah, next day.
What is the effect of your complaint when everything is over?
But the police,
People have died.
the police themselves have came up to the spot on the next day morning. Complaint was lodged next day morning at 9 a.m.
No,
And I was recorded the statement not after 1.5 or 2 months after the accident.
It's all not believable. Simple thing, you have to show what is the precaution you have taken. You have stated in your affidavit
Yes,
that you have taken precaution.
yes,
That is not supported by the IU.
he visited the spot next day.
How will somebody will remove the plant and tree and the stone? Will it go away? Will it go away? You are the only person. There was no other cleaner, conductor or anybody in the bus.
Conductor will be there.
Where is he? Have you examined him?
The driver will be there, but conductor has not been
They're
examined.
not examined.
Conductor has not been examined. Driver has been examined.
All right.
But here, by considering the spot of accident is within city limit, and it is on the national highway. Because of breakdown of the machinery, it was halted nearby the road median.
City.
The sketch may I request sketch.
How much percentage should be put?
It is equal against better, because by considering the nature of damage sustained by the tempo traveler, because the entire front portion of the
No, no doubt, I am agreeing with you that he was coming on high. You have the photographs? Photographs on the date of accident.
vehicles,
Subsequent.
vehicles.
During
Nature of damage sustained by the tempo traveler. Because of the entire front portion, that indicates the speed and negligence on the part of the driver of the tempo traveler. Because the entire front portion of the tempo traveler has been smashed. Front door and all.
Kachar, this is parked in after this, not on the road.
No, it is not on the road. To show about the nature of damage sustained by the vehicle.
Again, you are missing the point. Simple thing is you have to show that is a mandatory.
But that is the mandatory. But here, the time of accident is during evening time. It is not midnight or so, and it is within city limit. And when the other vehicles were moving on the left side of the road, the other vehicles were moving, but this tempo traveler came in high speed, uncontrolled speed. Because of his uncontrolled speed, he dashed to the rear side of the bus.
All right.
Because the IO about filing up charge sheet,
What is the negligence to be attributed to you?
50 tribunal has held, my lord. Therefore, I am before your lordship.
Yes.
My respect submission, my lord, I involve that judgment subject to your lordship.
Because after.
Yes, due to his negligence, the very accident was he parked in the middle of the road without giving any signal or indicate. As per the evidence of the petitioner who were the eyewitness to the accident, they have lodged the complaint against to the KSRTC bus, not against the tempo traveler. Charge sheet was filed against them. Therefore, my lord, in the place of accident, there was no street light or something what he says, what he has said. As admitted by the PW3, RW3. Therefore, the negligence attributed against the tempo traveler has to be.
Because
That's all.
IO himself has not admitted that he has recorded the statement of the eyewitnesses after 1.5 months from the date of accident. Then filed charge sheet. Whether it is having evidently available after lapse of 1.5 months, statements of witnesses have been examined. The facts on the record clearly shows that entire negligence of the tempo travel, but I can't say there is no negligence on the part of the driver of our bus. Because 50% money is reasonable and.
You are not in appeal.
No, we are not filed an appeal.
Perfect. That's all. Right. So you want to argue anything on the claimant's,
regarding enhancement is.
yes,
But though I have taken the defense in my appeal, but I am not much on that point, my lord. Only on the negligence aspect is concerned, I have filed it. Regarding enhancement, my lord, considering the nature of injury and the chart which was applicable to the present case, my lord,
that can be taken.
tribunal has not granted according to that, my lord.
So as per the chart, it can.
Chart, they
Right.
ಅದ್ರಲ್ಲಿ ಹೇಳು ಅದನ್ನ. ಹೇಳ್ದ್ಯಾ? ಸಾಕಾ?
These appeals are preferred. Challenging the judgment and award passed by the Chief Judge Court of Small Causes, MACT at Bengaluru. Full stop. The appeals preferred by the insurance company of Tempo Traveler is on the premise that the tribunal has committed an error in fixing 50% contributory negligence against the Tempo Traveler. Which he is seeking to be fastened entirely on the KSRTC bus. Full stop. Whereas the appeals preferred by the claimants is on the ground of inadequate compensation and hence seeking enhancement of compensation. Full stop. It is relevant to mention that the KSRTC, within brackets corporation, has not preferred any appeal and they have satisfied their share of the compensation to the claimants. Full stop. New paragraph. In this background, the facts of the case are as under. On 11/5/2017, the claimants and the deceased were traveling in a Tempo Traveler wearing registration number KA-05-AF-9869 to Kengeri to attend the marriage of the daughter of one Narasimappa. At about 7:30 PM, when the tempo traveler was proceeding on NH7 road and reached near Tirumagondanahalli gate, a KSRTC bus bearing registration number KA40-F-371 was parked on the middle of the road without any signal or indicator or signage. The tempo traveler dashed against the hind portion of the KSRTC bus and due to the severe impact, the inmates in the tempo travel vehicle sustained grievous injuries. And how many of them died in that accident? How many died?
Two.
Huh?
Driver and one Rajanna, two
Two of
persons.
them. All others are injury cases.
Please.
And 2 persons, including the driver, succumbed to the injuries. Full stop. New paragraph. The injured claimants filed claim petition seeking compensation for the injuries sustained in the accident, the disability, and the expenditures met towards the treatment. Full stop. The dependents of the deceased person filed claim petition seeking compensation for the death having occurred due to the negligence of the KSRTC bus against the corporation, that is KSRTC bus corporation, the owner and insurer of the tempo traveler. Full stop. The parties to the proceedings shall be referred to as claimants, corporation, insurance company, and the owner of the offending vehicle, owner of the tempo traveler. Full stop. New paragraph. The corporation filed statement of objections denying the claim of the claimants and sought for dismissal of the claim petition. The owner of the tempo traveler remained absent and did not participate in the proceedings. He was placed ex parte. The insurance company of the tempo traveler filed statement of objections denying the claim of the claimants, taking a plea that there was no negligence on his part. The entire negligence was on the KSRTC bus, which had parked the vehicle in the middle of the road and sought to exonerate himself and to fasten the liability exclusively on the KSRTC bus. The insurance company has admitted the policy having been issued to the tempo traveler and the same being valid. Full stop. New paragraph. On the basis of the evidence adduced by all parties, the tribunal awarded compensation in each of the cases according to the facts, magnitude of injuries, and the disability. Full stop. The tribunal fixed contributory negligence against the tempo traveler and apportioned the liability 50% each to the KSRTC bus and to the tempo traveler. And in view of policy being in force, directed the corporation to pay 50% and the insurance company to pay 50% compensation to the claimants, along with 6% interest per annum. Full stop. New paragraph. Being aggrieved by the inadequate compensation awarded by the tribunal, the claimants are before this court seeking enhancement, comma. The insurance company of the tempo traveler is before this court seeking to fasten the entire liability against the corporation and exonerate itself on the ground that there is no negligence on the part of the tempo traveler. Full stop. New paragraph. The submissions put forth by learned counsel for the insurance company of the tempo traveler is as under. As under. Learned counsel Sri BC Shivanne Gowda vociferously contends that the tribunal has committed an error in fastening 50% contributory negligence against the
The insured vehicle. Entitled to get the 50%. Only 50% is entered from KSRTC, not 50%.
whatever percentage if it
Please.
is.
The policy cover, personal accident to driver insurance coverage everyone.
ಅದು ಕೊಟ್ಟಿದ್ವಿ ಅದಲ್ಲ ಅದಕ್ಕೆ ಬರಲ್ಲ ಅದು ಓನರ್ದಲ್ಲ ಲೈಬಿಲಿಟಿ ಫಾರ್ ಇಸ್ ಸೋ ನೆಗ್ಲಿಯನ್ಸ್ ಈ ಕೆನಾಟ್ ಕ್ಲೈಮ್ ದಿ ಕಾಂಪನ್ಸೇಷನ್ ದಟ್ ಇಲ್ಲಿ ಅದನ್ನ ಬೈಫರ್ಗೇಟ್ ಮಾಡಲಿಲ್ಲ ಅವ್ರು ಟ್ರೈಬ್ಯುನಲ್. If he is a third party matter, I am liable to pay that compensation also. But for his own negligence, I am not liable to pay compensation. To that extent of whatever the negligence your lordship now is taking, to that extent of liability, he is not entitled to get. In this one, only in this case,
So
not other.
who's appearing in that case for the driver? What is the claimants?
Gauramma case, Gauramma.
4593.
Please no. 3295 of 21. ನೀನೇ ಇದೆಯಾ ರಂಗೇಗೌಡ?
Adral 18 lakhs is award.
Please.
So you are appearing for the drivers, that is claimants. So what's your submission? He says that he will not be entitled for your own negligence because he is the driver.
Admittedly, my lord, the charge sheet laid against the driver of the KSRTC bus. There was no negligence on the part of the driver of tempo traveler. Therefore, my lord, Claimant go against any one of the tortfeasor.
Can go.
In Kinay case, my lord, Claimant can go against any one of the tortfeasor.
Correct. You can go against any one of the tortfeasor, no doubt, that's the law.
Please.
But can you claim the amount where your negligent is fixed on you? That is his argument. Suppose what is now fixed is 50-50. Let us assume this court doesn't interfere. So 50% you will not be entitled. He says 50% from that person you will be entitled. That is his argument. Correct?
Correct.
Nim negligence anta if it is already held 50%, the driver will not be entitled to that. He will be entitled to 50% from the other side.
WC Act ಮೇಲಾದ್ರೂ ಬರ್ತದೆ.
Huh?
Under WC Act.
ಹಾಕಿದ್ರೆ ಬರ್ತಾ ಇತ್ತು ಸ್ವಾಮಿ. Correct. What he says is correct. If he filed the WC case, my lord, he is entitled, but he cannot opt both. He has already received the amount from the other insurance company, so is this thing is ceased.
Yes.
My lord, they have not taken.
We have taken contact. Sir, it's a
Contention.
question of law. For your own negligence, you cannot. Okay.
There was no charge sheet against the driver of tempo trailer. Entire negligence, charge sheet may not filed against the driver of KSRTC.
That in the case of the claim preferred by the dependents of the driver of the tempo traveler, the driver would not be entitled to compensation for his own wrong, and contends that he can claim compensation to the extent of liability fixed against the offending vehicle, that is the KSRTC bus. Full stop. On these grounds, learned counsel for the insurance company seeks to allow his appeal and consequently exonerate him and fix the entire liability on the corporation. Full stop. New paragraph. Learned counsel for the claimants in several petitions vehemently contend that the tribunal has failed to take into consideration the materials placed on record for awarding compensation. The income is taken on the lower side. The disability assessed is on the lower side, despite the opinion expressed by the doctor. Compensation under other heads is also on the lower side, which requires enhancement. On these grounds, it is contended that the compensation be enhanced and their appeal be allowed. Full stop. In the claim petition preferred by the dependents of the driver of the tempo traveler, learned counsel appearing for the claimants contend that the charge sheet and FIR has been laid against the KSRTC bus, the same has not been questioned by the driver. Therefore, the question of not providing any compensation to the dependents of the deceased driver cannot be acceptable, as the entire compensation, whether from the insurance company or from the corporation, would have to be provided and granted to the dependents of the driver of the tempo traveler. Full stop. New paragraph. I have heard learned counsel for the claimants, learned counsel for the insurance company of the tempo traveler, and learned counsel for the corporation, namely Shri Rangegowda, NR, Shri N.S. Varadarajan. For the claimants, Shri B.C. Shivani Gowda for the insurance company of the tempo traveler, Shri Dabali Fakirappa Sidramappa for the corporation. Full stop. The point that arises for consideration in these batch of appeals are whether point one, whether the accident that occurred on 11/5/2017 at about 7:30 p.m. involving the tempo traveler and the KSRTC bus is due to the sole negligence of the KSRTC bus. Full stop. Next point. New paragraph. Point 2. Whether the contributory negligence fixed by the tribunal at 50% to the insurance company and the corporation is justified, and whether the contributory negligence fixed against the insurance company of the tempo traveler requires to be set aside and shifted entirely to the corporation. Full stop. New paragraph. Point 3. Whether the claimants are entitled to enhancement of compensation. Full stop. If so, what amount? Question mark. New paragraph. The occurrence of accident, involvement of the vehicle, injuries sustained by the claimants, death of 2 inmates, including the driver of the tempo traveler, is established and proved by production of exhibits produced and marked in each of the cases. The tempo traveler having a policy in existence and having currency is not in dispute. We'll stop the full stop. The FIR and charge sheet is filed against the driver of the KSRTC bus. And the same is not questioned by the driver of the KSRTC bus. Full stop. New paragraph. On the basis of evidence adduced by the claimants and the respondents, the tribunal has fastened 50% contributory negligence against the corporation and 50% contributory negligence against the tempo traveler. Apparently, it is seen that the KSRTC bus was parked in the middle of the road. On NH7. It is not in dispute that the KSRTC bus had technical and mechanical failure and hence due to breakdown, it was parked by the driver and the breakdown had happened somewhere at 7:10 p.m. on 11/5/2017. Full stop. The accident with the tempo traveler occurred at 7:30 p.m. The claimants who are traveling in the tempo traveler along with the driver were proceeding for attending a marriage full stop. The driver of the tempo traveler has dashed against the hind portion of the KSRTC bus. Apparently, it is seen on the basis of evidence adduced that there was no sign, signal, or any indication with regard to the breakdown of the KSRTC bus. Due to which the tempo traveler dashed against the bus on the hind side. What is required to be analyzed is on the very set date, It is 11/5/2017. Apart from the tempo traveler, no other vehicle has dashed against the KSRTC bus. It is also an admitted fact that the driver of the KSRTC bus has not made any effort to put any signal of the breakdown of the vehicle, and no indicator lights were turned on to alert the oncoming vehicle to show that there is a breakdown of the vehicle. Full stop. The tribunal, having considered the entire evidence, came to the conclusion that there is 50% negligence of the KSRTC bus, and so also 50% contributory negligence against the driver of the tempo traveler, who has traveled in high speed and not taken a detour to avoid the KSRTC bus parked in the middle of the road. Full stop. Though the learned counsel for the tempo traveler, Sri B.C. Shivanne Gowda, vehemently contends that the entire negligence is due to the parking of the vehicle of KSRTC bus in the middle of the road, negligence cannot be attributed to the driver of the tempo traveler. And the contributory negligence would have to be shifted to the KSRTC bus. Whereas a learned counsel representing the corporation on behalf of the KSRTC bus contends that on the unfortunate day when the breakdown of the bus happened, no other vehicle met with the accident. All other vehicles had noticed the KSRTC bus having broken down and cautiously avoided the bus, took a detour towards the left, which itself is evident that the negligence of the tempo traveler is higher than that of the KSRTC bus, which had a breakdown. Full stop. New paragraph. On the aspect of negligence, I'm afraid I cannot agree with the submissions of learned counsel for the insurance company of the tempo traveler, that the entire negligence is to be fastened on the corporation. No doubt, the KSRTC bus was parked in the middle of the road due to breakdown. And it was certainly the duty of the driver of the KSRTC bus to have put signal, signage, some indicator to show the breakdown of the vehicle. Quite ahead of the area where the bus had a breakdown, which apparently is not forthcoming in the documents. Nevertheless, the driver of the tempo traveler was also traveling in a high speed. If not, he could have avoided the collision or damage that had caused. under the circumstances. This court is partly in agreement with the submissions put forth by learned counsel Sri B.C. Shivannegowda, and is of the opinion that the contributory negligence could be reduced on the part of the tempo traveler, fixing 30% against the tempo traveler and 70% against the KSRTC bus. In this context, it is relevant to note the Rule 15 of the Rules of Road Regulations 1989, wherein Sub-Rule 10 of Rule 2 speaks where parking is prohibited. In the case on hand where the KSRTC bus had broken down due to mechanical failure, it is the responsibility and duty of the driver of the vehicle to have informed the highway patrol team or the nearest police station to make necessary arrangement for towing of the vehicle, or in the alternative to make necessary arrangement to show indicators bar signal or any signage to depict a breakdown of the vehicle ahead, which would provide caution to the oncoming vehicle to slow down or navigate and avoid any collision. The same having not been done, the large portion of the negligence and liability would have to be fixed on the KSRTC bus. Full stop. Coming to the new paragraph. Coming to the aspect of compensation to be awarded in each of the cases, the tribunal has taken the income in each of the cases at 9,000 per month. The same will have to be enhanced to 11,000 as per the notional income chart.
Except in driver case 12,000 is taken.
Except in the case of MVC 4593 of 17, in the case of the death of the driver of the tempo traveler, where the income is taken at 12,000 per month, the same is retained. In the claimants cases, Mr. Rangegoda and Varatharajan, in the claimants cases, all the multiplier age and all is not in correct.
Correct.
You are not disputing on anything.
Please.
Only in Mr. Varatharajan's case, I think he's on the point of the disability.
Disability.
So all other cases, no dispute on the age and multiplier.
Please. They have challenged only, ES challenge 3 appeal, Malad. ES challenge 1 appeal. In those 4 appeal, enhancement is required. In all other cases, only the negligence aspect. Therefore, is appeal.
All other cases will have to be retained.
Please.
So only in the cases filed by them.
Please. That has to be adjudicated.
So that is
4406.
the 3.9, 3.10, 11 and 12 stay.
Sir, please.
The claimants in 4 cases are before this court seeking enhancement. In these 4 cases, the age so adopted by the tribunal is not much of a dispute. The multiplier adopted is correct, does not call for interference. What is the MVC number in
My case it is 483 or 483 of 2017.
First time you seen.
what's the number?
4482.
483 of 2017.
In MVC, four four eight three.
Of 2017.
In MVC 4483 of 2017, apart from the age and multiplier, learned counsel for the claimant contends that the doctor has opined disability to an extent of 18% to the whole body, whereas the tribunal has taken disability at 10%, which is on the lower side. I'm in part agreement with the learned counsel for the claimant, and as there is no contra material evidence placed on record, the tribunal has reduced the disability to 10% from 18% opined by the doctor. Considering the injuries sustained, this court is of the opinion that 15% could be taken as a disability in this case. Full stop. Under the circumstances, each of the cases before this court in challenge, the judgment and award could be modified as under. Full stop. New paragraph. In view of the discussions made herein above, I pass the following order. The appeals preferred by the insurance company of the tempo traveler is allowed in part. The contributory negligence fastened against the insurance company of the tempo traveler is fixed at 30% as against 50% by the tribunal. 70% of the liability is fixed against the KSRTC bus. The claimants in each of the cases shall be entitled to compensation as stated against each case, which is stated herein below. The balance compensation shall be paid by the corporation and the insurance company within a period of 4 weeks from the date of receipt of copy of this order. The trial court records shall be transmitted to the jurisdictional tribunal forthwith. The the statutory, along with the statutory deposit and amount, if any, deposited before this court to the jurisdictional tribunal.
After adjusting a balance amount, maybe if any excess.
Full stop. The balance amount, if any, paid by the insurance company of the tempo traveler shall be adjusted. And if any excess paid shall be refunded to the insurance company, ordered accordingly.
Money is deposited in this court at the time of admission, and that may be transmitted.
ಅದನ್ನೇ ಹೇಳೈತೆ.
Very good.
So the in detail of the whatever you have argued shall be granted. Please. So in your case, 15% will be taken as against 10%.
12,000 rupees.
11,000.
11,000.
11,000 in all the cases except the driver's case, 12,000 will be raised. Photos for today. Correct. Claimants' appeal are also partly allowed. Appeal preferred by the claimants are partly allowed. Ravi Shankar. Gopal Krishna. None appears when the matter is called. Call next week. Santosh Nel. None appears when the case is called. Call after a week. Chandrasekhar. Same, none appears.
For the appellant, my lord.
Yes.
Only.
Lord, this
Respondent
case of
also
injury.
preferred an appeal for announcement.
Please, my lord.
Is pending before division bench, madam.
And moreover, I have just informed my appellant to propose some amount for settlement, my lord. If at all it is possible, we'll settle the matter, my lord.
Howda?
Yeah, ಹೇಳಿದಾರೆ, we will consider.
Learned counsel for both parties submit that there is a possibility of settlement. Hence to report settlement, call on after 2 weeks.
Please, my lord, please.
Shivana Gowda, withdrawal of the amount. Any objection?
Dispose ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು.
2024 ಇಲ್ಲಿ dispose ಮಾಡೋದು admit ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಅವ್ರೇನೋ ಒಂದು ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿದಾರಂತೆ. ಅದ್ರ ಜೊತೆಲಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನಂಬರ್ ಏನು?
ಅವ್ರ ನಂಬರ್ ಕೊಡ್ಲಿಲ್ಲ, ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ರು. ಅದಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಐ ವಿಲ್ ಗಿವ್ ಯು ದಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಓನ್ಲಿ ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ವಿನೀಸ್ ಜೈನ್ ಜಡ್ಮೆಂಟ್ ಪ್ರಕಾರ.
All right.
I will
call this
next
matter
week.
after 2 weeks.
But please.
Anup Sitaram Rao. And appears when the case is called. Lingaraj. Call this matter after 2 weeks. Benny. Sorry, Learned counsel
policy plea.
for the appellate.
Limits of the vehicle.
Issue notice to respondent. Shall be stay of operation execution. Order dated 5/11/24. In MVC 689 of 23. Passed by the additional MACT at Bhadravati, subject to the appellant depositing 50% of the award amount. within 2 weeks before the jurisdictional tribunal.
I'm seeking the dispense notice to dispense, the second response. He is a driver. 1 and 3 can notice. Owner and claimant. Sorry.
Notice to,
Second response may be dispense, please.
notice to R2 is dispensed, issue notice to R1 and 3.
And kindly call for the TCR also.
Check your records.
I appear for petition.
Correspondent.
Lord, the petitioner challenged the order passed by the family court, my lord. Earlier, my lord, the petitioner is the husband. Earlier, my lord, earlier litigation, my lord, the respondent, the wife of the petitioner and 3 children, they approached the family court, my lord, earlier for maintenance in criminal misdemeanors 121 of 2016, my lord.
There's a stay, is it?
My lord, it is
Yes,
stay,
proceed.
my lord.
So it has to be heard on the main.
Yes,
Both of you are ready?
yes, I am ready. Yes, my lord.
Yes.
My lord, in this case,
Next week.
please,
What is the, now, this is on the main
please,
petition, right?
please.
The enhancement. Actually.
No, is there any other petition pending before the court?
One civil suit is pending before the court.
Suit is pending.
Partition, suit for partition filed by the wife and children, my lord.
What is the amount now ordered by this court?
Lord,
5,000 each, my lordship. With the 2 minor children.
Hmm.
So
My lord.
earlier the court has.
Lord,
passed
earlier, my lord,
10,000 was.
1,000 per month. So now is enhanced to rupees 5,000 per month.
without considering the documents and evidence, my lord.
The first petitioner is studying in Vidya Jyoti PU college,
the
second
husband.
PU. Shows they are paying the school fees and tuition fees.
The impugned order is against the evidence and records.
Yes, this, is a capable, he is clearly admitted in his cross examination.
1,000 per month.
Kindly see the cross examination of the PW.
It's only the children who are before the court.
Yes,
So 5,000 each is ordered.
Yes.
my lord, earlier litigation, my lord, 3,000 was awarded to the wife. It is not at all challenged.
Oh,
And now
5,000.
the mother filed the petition on behalf of the 3 children, seeking announcement of the maintenance from 1,000 to not 10,000. But the family court awarded 5,000 each.
What is
That
the
I challenged before the sum.
What is the modification by this court? What is ordered to be given now?
No, my lord, my submission is, my lord, I am the 65% disabled handicap, my lord. And the respondent herein, they sought for announcement of the maintenance from 1,000 to 10,000. But without producing any document to say that I have so
now,
much.
now nothing you are paying.
I have been paying. Till filing of the petition, announcement petition, I'm up to date. But there is no pending, my lord. After filing of this petition for announcement, there is a pending one.
So there's a stay now, you're not paying anything.
No,
he's
after
not
stay
paying.
of.
So only 1,000 rupees is paying. Each children 1,000 rupees.
ಕೊಡ್ತಾ ಇದ್ದಾರಾ?
Yes, 1,000 ಕೊಡ್ತಾ ಇದ್ದಾರೆ. So ಇಲ್ಲಿ 5,000 ರೂಪಾಯಿ ಹಾಡ್ರ.
Or we listed for final hearing and hearing.
ಆಗ್ಬೋದು.
Because now this is a 2024 matter.
Record ಬಂದಿದ್ರೆ record ಬೇಕಾಗುತ್ತೆ.
What's the requirement of the records? In
ಬೇಕಾದ್ರೆ
Not required.
or otherwise I can produce the certificate copy.
I am producing
What?
the doc.
Of what?
Lord, the evidence and exhibits R1 and 2. I will produce. Copy.
You produce it. List
Please.
this matter
According
for
to
hearing.
this, I am producing the documents.
You can exchange and produce whatever. List
Please.
this matter for hearing. Call after 2 weeks.
Interim order may kindly best.
Interim order extended till next date.
Yes.
Here to the respondent, this matter may be connected with the WP 522 of 2015. That is the MC case. This is the restitution matter. Your
So-
lordship, that matter came up before your lordship on Saturday, sorry, and your lordship has directed the matter to be posted on the 18th. In the meanwhile, your lordship has directed us to file our objections. We'll
So
do
this
that.
has to be connected with?
Yes, please.
Connected with?
522 of 2025.
No, that is here today.
No, sorry, 713 of 2025.
25.
Yes, please.
So that is filed by whom?
That's it. Both have been filed by the wives.
It is now posted on 6th.
6th, 18th, 18th is what I'm told. It was there on Saturday.
This is the matter in which they had taken adjournment at
In the
the.
morning,
Well,
I'm told, my colleague, I believe, mentioned in the morning, that requesting your lordship to post both the matters together.
All right. So, list this matter along with MC, WP 713 of 25, correct?
Your lordship,
All on 6th.
please, if it is 6th, please, I'll wait. That is. I appear for the petitioner in the matter.
Yes, ma'am.
I have challenged the order granting visitation rights of overnight visitation rights to the respondent, your lordship.
Hmm.
Now, the petitioner and respondent were married on 14th February 2019, and the child was born on 24/7/4/2011. Now, thereafter, from 2017, she is staying in her mother's house with the son. Now, the respondent has filed a petition for restitution of conjugal rights in 2021. And on 14 July 23, he files an application for visitation rights and interim custody of the child for 1 day. Now, the petitioner has filed the objection stating that she is agreeable for him to meet from 2 to 7 on Sundays in her presence. But the court has passed an order directing that the visitation rights should be granted from Saturday 6 p.m. to Sunday 8 p.m. Now, the child is scared to go alone with the respondent.
How old is the child?
Child is now 13 years.
13.
Yeah,
Son.
yes. But he is not ready to go with the respondent alone.
Father.
Yes.
Why he has not been seeing the father?
No, in between, he has not been in touch, basically. Whenever he meets with the petitioner only. So he is not comfortable with the father alone. And the court, without speaking to the child, also has directly granted interim custody from 6 p.m. to. And video conference is granted, but that we don't have any objection to him calling up or having video conference.
All right. So now what is granted is 6 p.m. from Saturday to 8 p.m. Sunday.
Yes,
So that is overnight on Saturday.
yes,
So you are agreed by that.
yes.
Thirteen-year-old.
Yes.
In which class the boy is studying?
Now he is in 9th standard.
Which school?
School, I'm not aware.
And where are they staying, these parties together? Somewhere close by to each other or JP Nagar, BTM?
JP Nagar, and he's staying in BTM.
All right. Do you have any difficulty in the child visiting the father during the day?
No, but it is with the with the petitioner. Along with the petitioner, he has to go because he is not ready to go alone without the petitioner along.
No, but apart from this overnight visitation, was there any other visitation in between arranged for the father to see the child?
No. This is the first application which he has filed after
So
20.
this is ordered in 24.
On 9th
September-
December 2020.
December. And petition is filed in 2021.
Yes.
So he has not met the child before the order.
No, he used to meet during the PTA meetings. That was all. And once or twice he has come home. That time she has permitted him to see the child. But he is not regular in visiting the child.
So if an order is passed permitting him to see the child on Saturday and Sunday, what's the difficulty for you?
No, it is in the absence of the petitioner,
Correct,
petition.
but he's a 13-year-old boy.
No, the difficulty is that he's scared to go with the father. And that is why he has also written a message to the father saying that I'm not ready to come and stay with you, but I can come and spend time with you on Sunday along with the petitioner. But
So
he's
after this order, this has not been complied.
No, once she has taken the child to his house and they have met and come. Before that, she was in Bombay during the vacation, so she could not comply with the order. And last Saturday also, she had gone out, so she could not comply. So once she has taken the child to the house and gone.
Now, what is the stage in the proceedings?
It is for the cross-examination of the petitioner. That is the respondent hearing. He is the petitioner before the trial.
So where was he seeing the child earlier? Which was a place designated?
No, there was no designated place as such. The
He used to come home and meet the child.
Yeah, he used to come home once in a while. Otherwise, she used to take, if he said that his mother had to see the child, then she would take the child and go to his house and make him meet the mother.
So you have any objection in the father coming and seeing the child in your house?
No. That he can come and see the child in the house.
All right. So we'll modify that to Saturday morning to Sunday morning and evening.
No, it can be one day on Sunday because Saturday sometimes he has school.
Sunday.
So Sunday.
Heard learned counsel for the petitioner. Issue notice to the respondent. Learned counsel for the petitioner is permitted to take out notice to respondent by hand summons or other modes of communication, including notice to the counsel for respondent before the family court. There shall be stay of operation of the impugned order dated 9/12/24. Passed on IF4 in MC 883 of 21. Full stop. However, the respondent shall be permitted to visit the minor child on every Sunday.
They have given alternate Sundays.
Alternate Sunday.
Yes.
Between 10 a.m. to 4 p.m.
Yes.
10 a.m. to 4 p.m. till further arrangement is made on appearance. Call this matter. The data. What is today? Call this matter on 13th. 13th or 14th. 13th or 14th.
February.
We'll see after appearance if there is any possibility.
Okay.
So no possibility of settlement.
No, he is not ready. She is not ready to join him, but he is not ready for a divorce.
All right.
In this case, my lord, the parties are living together now.
Living
together, my
very
lord.
good.
Please.
Confirming.
Yes, confirmation.
So what now? You want to withdraw?
Withdraw, my lord, with according the both are they will not press the pending cases pending before the trial court and before this court.
What are the cases pending?
Divorce case is pending before the trial court, my lord, and also no criminal miss petition is pending,
Well,
and
it's a joint
498 is also pending.
We will file a joint memo. A date may be fixed, your lordship. We'll seek further instructions from the client and we'll place a joint memo before your lordship.
This is on an application.
This is an application, my lord.
So now you better file a joint memo or something.
Please.
With the signature of the parties.
A party petitioner is present before this court.
No, you put to keep the respondent also present.
Please,
Please, your lordship.
So that there is something on record. As a child also involved.
Please, your lordship.
So now they are residing together.
Yes, my lord. For the last 3 months, there is.
What was the proceed, apart from this criminal miscellaneous, what other proceedings? was-
498 is pending.
And?
And also he filed, a petitioner filed a divorce petition before the family court. That is also pending.
So that has to be withdrawn.
Yes, my lord.
And 498 also has to be compounded
That is a stay by this honorable court, my lord. That's pending before this court.
in criminal petition.
Criminal petition.
Yes, what is your name? You are residing with your wife now?
Yeah.
So you will withdraw your divorce petition?
Yes.
No problem between both of you? All right. So I'll post it next week. You file a joint memo.
Please.
Then meanwhile, you can move the criminal petition and seek for compounding or withdrawal, whatever you want. Learned counsel for the petitioner and respondent together submit in the presence of the petitioner that the petitioner and respondent are residing together after having settled their differences. They intend to file a joint memo to this effect and call this matter on.
Parties may be present, kindly direct.
Parties to be present before the court.
Please.
Please,
I appeal for the respondent wife, my lord, 20,000 awarded maintenance.
Lordship,
Every time he submitted that, their settlement,
like every time, Allah, because of your Lordship,
the order.
I will,
Another 40,000 has been deposited up to date.
No, that deposited in the.
Deposit money is
No, ಅಲ್ಲ settlement ಮಾಡ್ತೇನೆ ಪ್ರತಿ date ಅಲ್ಲಿ.
Allah, pretty date, Allah, Lordship. Allah, 1 minute, Lordship, because he has lost his job and father is going to settle a matter. Father is last month has admitted to the hospital for the heart surgery. He is last week only discharged. He must come and settle the matter for payment of so and so, Lordship. That's why we are waiting for the coming from Hyderabad to Bangalore. That and also he has 65 years old and two those are blocked and he has 2 stents are formatted and also discharged from the last week only he has gone to the doctor. 1 month time may fix it. Otherwise, you go on with the matter. No question of dragging on the proceedings. And also, Your Lordship, I as per this court order, I have fully complied. Along with the up to February, we have deposited another 40,000 before this court, Your Lordship. We are not going hiding back. There is no issue. And also, she is residing in Bangalore. He is residing in Hyderabad. And no 2 times our mediation has been taken place. No fruitful will be come out. That's why, Your Lordship, father is come for the discussion in High Court also last 6 months back. Because of this reason, I want time. Otherwise, Lordship, left to Your Lordship's decision.
So 10,000 is the amount that is ordered.
Yeah. It is
that
fully
is-
complied with.
That is modified by this court or you are paying that amount?
We have modified by this court. As per this court direction, we are deposited entire amount till February.
How
Lordship.
much? Where is that order?
8,000. Lordship.
So this court has reduced it to 8,000.
8,000.
Earlier,
Up to February, we are deposited.
The entire arrears is paid.
Entire, no arrears of affordability.
now these are a 5th or a 6th time he is submitting that he is going to settle the matter. But no,
And,
they are coming for a settlement. Once for all, it is a headache for her also. And she is totally
Lordship,
trying desperate.
conjugal rights you have filed, Your Lordship.
Let them settle and let them.
And
go ahead.
there is 5 maintenance. We filed the divorce case before the mediation is failed, Your Lordship.
They have filed RCR.
Now you have filed for divorce.
Divorce, and they have filed for conjugal rights.
All right.
Mediation has been held, Your Honor. But they are not fruitful, will come and there is no other end. And we discussed it. And after filing this divorce petition, they come for compromise. And because of this reason, Your Lordship wants time. That's all.
Compromise is what? Part separating.
Separate.
Separating and even she.
Even
ready to
2 years
separate
back, Your Lordship, it is not 1 or 2 days.
By next week.
That's why, Lordship, because of
Going to the case.
medical, this one, we want time
Right
to.
now, this.
Otherwise, I don't want to seek time, Your Lordship.
Now-
Because
now
a
that-
father is only the payment. Payment has to be made by the father.
No.
That is the reason.
Ivaga, there is no joining. Reunion is not possible.
ಏನು ಕಂಪನ್ಸೇಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಏನೋ ಹಣ ಕೊಡ್ತೀನಿ ಅಂತ
ಅದು
ಹೇಳ್ತಾರೆ.
ಮಾತುಕತೆ
ಹಣ-
ಆಗಿದೆಯಾ?
ಮಾತಾಡ ಫಿಕ್ಸ್ಡ್ ಅಂದ್ರೆ ನಾವು ಹೇಳಿದ ದುಡ್ಡನ್ನು ಕೊಡೋದಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ ಅವರು. ಈವನ್ ಸಿ ಡಿಮಾಂಡಿಂಗ್ 50 lakhs ದೇ ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಪೇ. ಏನು ಬಂದ್ರೆ ಅವ್ರು ಇಲ್ಲಿ ಬಂದ್ರೆ ನಮ್ ನೆಗೋಸಿಯೇಷನ್ ಮಾಡಿ ಒಂದು ಸರ್ಟನ್
ನೀವು ಕೂತ್ಕೊಂಡು ಮಾತಾಡಿ ಮತ್ತೆ ಇಬ್ರು.
ಅಲ್ಲ,
ಅಷ್ಟೇ,
ಮಾತಾಡ್ಬೇಕು
ಅದಕ್ಕೆ
ಸ್ವಾಮಿ,
ಅವ್ರು
ಅವ್ರು
ಬರ್ತಾ ಇಲ್ಲ.
ಅಮೌಂಟ್ ಲಾಶಿಪ್. Father is come and settle once for settle and close the matter. That's why.
Settlement ಆಮೇಲೆ ಫಸ್ಟ್ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಪೀಕ್ ಟು ದ.
ಅಲ್ಲ, ಆಗಿದೆ ಸ್ವಾಮಿ, ಆಗ್ಬಿಟ್ಟು 15 lakhs ಏನೋ ಬಂದಿತ್ತು. Then they will come because of.
in 50, they say 15 lakh.
That is
And-
why now if there is no meeting point, why don't you both sit outside and talk to your clients over the phone and
Let them come
communicate?
before. Now father is suffering from what he says, the father is suffering, but let him come along with the mother.
Mediation ಹೋಗ್ತೀರಾ?
ಅಲ್ಲ, ಹೋಗೋದಿಲ್ಲ ಲಾಶಿಪ್ and fix the date.
No, now.
And ಅಲ್ಲ, ಅವ್ರಿಗೂ ಕೇಳ್ಬಿಟ್ಟು ನಾನು ಹೇಳ್ದೆ, ಯಾಕೆಂದ್ರೆ ಅವ್ರು ನೀವು ಲಾಶಿಪ್ I told the at the stage of the call. That's why I will telephone to you and fix the date for that one ಲಾಶಿಪ್.
No.
ಯಾವಾಗ ಬರ್ತಾರೆ ಅಂತ ಕೇಳ್ತೀನಿ ಬೇಕಾರೆ.
His father is not required. He can be there.
Correct, ಲಾಶಿಪ್.
You are the party. You speak and find out what is the amount you are willing to settle. If that is not agreeable to him, then there he need not wait for his father to come.
And mother, let him come.
You have
along
to
with his
either
mother.
go on with the matter, and if his agreement of settlement.
We have saying
Right.
that, we are saying that amount after deducting the deposit, we've shared 15 lakhs. Whether he's upgrade or not, you can say like that, why should we unnecessarily go to the mediation to come back? Because
No, I'm not sending it to mediation. I'll fix a date next week. In the meanwhile, you speak to each other.
Yes.
If at all your meeting is requirement, which is satisfied to him,
yes, Your Lordship.
then only it is be required to whether consider granting of further time for settlement.
ಹಂಗೆ
He
ಮಾಡಿ.
is not agreeable to the amount which you are going to quote.
Yes, Your Lordship.
There is no point in further.
Correct, Your Lordship. I am not big, because that's why once, Your Lordship, before this court only, we are discussed entire family along with him. That is a demand made by the otherwise 50 to 25 and gold and other ornaments are retained and they beg. This is the discussion.
ಕೆಲ್ಸ
We are
ಮಾಡ್ತಾ
not
ಇದ್ದಾರೆ?
thrown out the other discussion.
What
He's
is
only
your-
say
what-
50 lakhs.
what is
He
your
can
client-
depend to close together. I'm not worrying
Shankar,
about that.
what is your
Ah.
client doing? What is your client doing?
If you go and lost the job, Your Lordship, he is a software engineer, lost the job. He has no job.
No, they will say.
They will say, no, he must produce the document.
And he has got a property in the village.
Property is in, father is there.
ನಿಮ್
But
client
he is not working.
not working.
Not working.
ನಿಮ್ client ಏನು ಕೆಲಸ ಮಾಡ್ತಿದ್ರು?
Engineer ಆಗಿ ಮಾಡ್ತಾ ಇದ್ದ ಹೈದರಾಬಾದ್. He left the job and.
Engineer.
ಹಾ. ಅದಕ್ಕೆ ಲಾಶಿಪ್ 25th or 24th.
Produce where he is working, what is the income that he is getting?
No, that he has to produce.
Why
ಅವ್ರು
should I?
produce ಮಾಡ್ತಾರೆ.
ನಾವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. ಅಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ.
Have you both,
24th, Your Lordship.
have you both produced assets and liability?
No, we have submitted
They have submitted.
as an liability before.
You
the
have
family
submitted.
court. Yes.
You have not submitted.
I have also filed, Your Lordship.
Where is it?
ಅದು in the
Before this court or the family court?
family court, Your Lordship.
Court.
Family court, not here.
The same will continue.
Produce it here.
Lordship,
Produce it here before this court.
produce before the.
Same, will-
That is, you are not disputing both. That is noted by the family court in the order.
Yes, Your Lordship. After that only, because we have filed the objects, because what had happened, Your Lordship, when mediation is going on, they have filed the, for this one, compromising is going on. After that, Your Lordship, they pressurizing for the maintenance. They passed the, after filing the application, they passed the order on the reconciliation of 5899 of 21. Then we filed the divorce case of 6156 of 2023. That is pending before the court for the consideration.
According to you, is the wife working? Is she working?
Pardon?
It's not working.
Is the wife working?
But as per the, my client is, she is working in Bangalore. I don't know.
Where?
ಅದಕ್ಕೆ we are not getting any piece of paper for evidence.
ಅದು ಕೊಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
ಅಲ್ಲ, ಕೊಡ್ಬೇಕು. ಅದಕ್ಕೆ ನೀವು 24th 20 ಮಾಡಿದ್ರೆ ಆದ್ರೆ ಒಂದೇ ಸಲ ಮುಗಿಸಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Fourth,
ಅಲ್ಲ,
long date by next week, my lord.
Fix a date next week.
14/2, sir.
All right, call this matter on
14/2.
18th.
14th February.
ಆಯ್ತು, ಕೇಳ್ತೀನಿ ಸರ್.
Finally,
So finally, on
After
that
that,
day,
he
you
will-
either argue the matter or.
Yes,
settle.
Your Lordship. And this amount has been paid, deposited, Your Lordship.
Which about?
The,
ಅದು
Maintenance what
ಇಲ್ಲಿ
you-
ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾರ ಅವ್ರ ಅಕೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ, ಕೊಟ್ಟಿದ್ದೀನಿ.
You have withdrawn that?
Last occasion you already ordered, Your Lordship.
And
It is already ordered by
filed
this court.
application, I have filed voucher for the previous deposit. That was not released.
No, order for withdrawal is already passed. You
Already passed, Your Lordship.
can
Already.
withdraw whatever amount you have.
Interim order may be extended, Your Lordship.
Again,
I may be permitted to withdraw this.
that's what I am asking you and you're saying.
My lord.
So that is a 2,58,000.
That will be a fine,
And-
application.
That you have withdrawn?
Not withdrawn, not yet withdrawn. Order has been,
I have already passed that order.
we have submitted
So
voucher.
after that amount, you have
After that.
deposited any further amount?
Yes, Your Lordship.
How much?
16 and 40,000.
16 and
40,000.
40,000.
69, 40,000, 16,000 we have submitted voucher.
Work was
What
done
is
at
that?
counsel for the petitioner.
40,000.
Submits that he has deposited 40,000 as arrears. Respondent is permitted to
Or in
withdraw the
today.
amount before this court.
Yes, Your Lordship.
Registry is directed to release or disperse the amount in favor of the respondent upon proper identification.
Yes, Your Lordship. Interim order may be.
Interim order extended.
Much over.
Petitioner. There was an order by this honorable court to file my assets and liabilities minutes. I'm filing minutes.
What documents are there? ಎಲ್ಲ documents.
Court ಅಷ್ಟೇ.
ಕೊಡಲ್ಲ.
ನನ್ನ ಹತ್ರನೂ ಇಲ್ಲ.
What is the order that is in question?
My lord, this is regarding questioning the maintainability of the petition, my lords. Lordship will find that the impugned order.
From submission, not assets and liability, I have only given minimum.
Affidavit I have given, my lords, and one annexure is annexed.
Only 10 pages are there. Looks like it's filed a voluminous.
The bank statements are produced before this
ನನಗೊಂದು
court.
Copy ಬೇಕು, because I have for the judgment, I have a right to file objections if there is any.
So what is given to you now?
Affidavit is
Only 10
given.
pages.
Affidavit.
Affidavit is
Affidavit
given.
only. And there's one page which is statement by State Bank of India. So nothing else.
And annexure A is also given. It's a pension slip, my lords.
So you want this court to only look at annexure A?
No, annexure A is the pension slip, my lords. That is the only income he has. And I've given the entire bank statement as per the requirement of the Honorable Supreme Court. Insofar as filing assets and liabilities.
Where is your assets and liabilities?
I've also
already
annexed,
filed it before the trial court.
I've annexed, my lords. Annexure, last document, my lords. Kindly see page number 160, last documents, my lord. It contains 8 pages. But that also, no annexures are placed.
No, I don't have any annexures. because
According
he
to
is
my
not-
instruction, she has a bank account, my lords.
ಅಲ್ಲ ಅದು ಅವ್ರ objections ಹಾಕಿದ್ರೆ will definitely file it. ನನಗೂ ಈಗ now also, Lord, there is a specific order by the trial court directing him to file assets and liability, which he did not do. Then he challenged maintainability before this honorable court, and this honorable court directed him to file assets and liability. Now he is filing it. So the order of trial court was not complied there. Now he is filing it not. Even my assets and liability also, he was not, he did not raise any objections.
All right, what is the order that was passed before the trial court?
Please, my lords.
What is the order?
You see, in this petition, my lords, what I've challenged is regarding the maintainability, my lords. I'll just give the brief facts, my lords. The main petition was filed by, filed under section. Page 30, ink page 31B taken, my lords. Annexure B. The maintenance petition, my lords. This petition was earlier filed
under section 7(1)(f) of Family Courts Act, read with section 21 subsection D, 20 subsection 3 and 26 of DB Act, read with section 125 of CRPC, my lords. Initially, we raised the objection regarding the maintainability because the parties are belonging to Islamic faith, my lords. See, maintainability came to be overruled on the premise that they have invoked section 125 of CRPC. That is why even a divorced Muslim woman has a right to file section 125 petition, is what the family court held, my lords. Thereafter, we went on with the matter. What happened in the meantime, my lords? They withdrew that 125 provision, my lords. They withdrew that 125 provision, and thereafter I filed an IA seeking maintainability because essentially now the petition is only under section 7(1)(f) and provisions of DV Act, my lords. If at all, if they want to prosecute under DV Act, they have to go before magistrate, not before the family court, because my right to appeal would be lost, my lords. That is the primary ground on which I have presented this, filed my IA. That came to be rejected, and that I have challenged before this honorable court. And after rejecting my maintainability IA, they filed an application seeking a direction on me to file my assets and liability because the matter pertains to 2014. So initially on orally, they were making request. Subsequently, they filed an IA. I was before this honorable court, that's why I could not comply.
Actually, you filed a petition under 125.
Lord,
Annexure B, my lords.
Annexure B, which they have filed, my lord. It is not just 125, my lord. It is filed under
What is the petition now pending?
Now pending is only under section 7(1)(f) and
page
under the
number
provisions
31,
of DB Act, my lord.
page
Annexure
number,
B, it is forthcoming, my lord.
page number 31, Annexure B. Kindly see, my lord, memorandum of petition under section 7(1), explanation F, Family Courts Act 1984, read with section 20, subclause 1D and 20, subclause 3, read, and section 26 of DB Act, and read with 125. Lord, my prayer at page number 40, my lord, 41. Directing a sum of 50,000 rupees per month regularly, and then provide alternatively, provide the petition with assured permanent source of decent and dignified livelihood, directing and regularly by fetching her a monthly minimum income of 50,000 rupees, or in alternative to pay petition one-time lump sum is what I have sought, my lord, and then interim maintenance also I have sought of 50,000. Lord,
This matter is pending before which court?
Family court.
Lord, fourth
Lord,
additional principal judge family court.
Lord. I have completed my evidence. He said no evidence. He did not even step inside the witness box. His main contention is he has given me instant talaq.
No instant, it's not an instant talaq.
Triple talaq single-handedly behind my back. And the contention that is being taken, my lord, is 4th month itself he has given talaq anta. After 7 months, 4 days, he sends me a notice.
No, the question is, what is your prayer for maintenance? Please, have you withdrawn the provisions of 125?
Yes, my lord, page 59.
Lord, because he filed he took a contention, I filed my rejoinder about talaq, that I have already divorced the respondent, and he took a contention. So I wanted to amend my application, filed an amendment application to bring declaration that his contention is invalid. I'm a lawfully wedded wife, and I filed an application. There was a complexity at that point of time, my lord.
That came to be rejected, and that was not challenged till today.
That point of time, my lord, now it is settled law that even DV proceedings early amendment is permitted, CPC is permitted. At that point of time, it was not there. So I, for the convenience of the court, my lord, I withdrew 125. But my petition under 7 as well as DV was intact. It is only read with, I have sought for 125. Still, it comes under criminal miscellaneous only. In that connection, Lord, there are judgments that whether Family Courts Act is relevant or not is the issue, my lord. Now, my the petition that I have filed is, my lord, is 7 subclause 1 and F. Now, what does that speaks as well as DV actually, section 21D and.
Okay, what is the now
26
impugned order?
Impugned order is, my lord,
Rejecting my IA.
his IA has been rejected, saying that petition is maintainable. That is being brought,
What is
questioned
7?
before this honorable.
Family courts.
Yes.
Section 7, my lord, jurisdiction. Subject to other provisions of this act, family court shall have. In that, my lord,
No, you come to the F, we
F,
are invoking on the F.
F is a suit or proceedings for maintenance.
Hmm.
Proceedings for maintenance is there. And my lord, I have also sought for 21 of DV Act. That provides 20, subclause 1, subclause D provides for maintenance, and subclause 3 provides for lump sum. This is what my prayer is also before the.
No, but you said that you have withdrawn that 125.
125, I sought for interim maintenance, my lord. That anyhow court did not grant it. And the case went on, evidence, everything got over, my lord. So I withdrew. That will not deprive me from claiming benefit under 20 subclause 1D as well as 3, my lord, because my prayer stands still as far as that is concerned.
For maintenance.
For maintenance as well as lump sum amount that I'm seeking, because it is not a case for divorce, my lord. I have not sought for divorce. I only sought for maintenance, my lord. Maintenance and as 20 subclause 1 and also suit for
Maintenance
maintenance.
under which provision? Maintenance you are seeking under which
I
provision?
may be permitted to read, my lord. Monetary relief under DV Act, my lord.
No, you are invoking DV Act under the provisions of the DV Act before the family court.
Yes, my lord. I come to that, my lord, because it is also read with section 26 of DV Act. Now, 26 says, I may be permitted to read that also, my lord.
26 of
DV Act.
Could you?
Relief in
Protection.
other suits or legal proceedings. Any relief available under section 18, 19, 20, 21, 22 may also be sought in any legal proceedings before a civil court
That is an ancillary proceedings which you can file in any proceeding before any court.
Yes.
But that is ancillary, that is not the main.
Lord, my main is 7 only, Lord. 7, as I read now, Lord. 7.
What is 7?
7
is only the jurisdiction.
1, yes, my lord. Section 7 is what is provided. I'll rely upon some judgments, my lord.
So you have not filed a suit, or what is the proceeding? You're proceeding for
Criminal
maintenance.
miscellaneous only. The office has given the name criminal miscellaneous only, my lord. All these things, criminal miscellaneous
So
is
criminal
what
miscellaneous under which provision?
Lord, it is for, my lord, office objection was not there, my lord. For all these provisions, it was named as criminal miscellaneous only.
Criminal miscellaneous means it has to come under the criminal procedure code.
Yes, my
Or
lord.
can it come under the civil procedure?
That is what, my lord. Now, my lord, now there are judgments which says CPC is applicable to DV proceedings also. Criminal miscellaneous also, as far as application of CPC is concerned, now it is being settled. Previously, it was not there, my lord. It is a pure criminal and only CRPC is applicable. Therefore, my lord, my amendment application was dismissed.
The fact remains that the proceedings that you have filed before the family court, according to you, is under the Domestic Protection of Women
No,
of
no,
Domestic
not
Violence
alone,
Act.
not alone. Family Courts Act read with domestic violence and read with.
Already you argue. Both of you are ready to argue today?
Yes.
Lord, before that, my lord, complete papers may be given.
You hand over one set of copies of whatever you have given.
Please, please.
When you are relying on some documents, you are expected to give one set of copies.
I'll provide.
You cannot give two sheets of paper.
No, entire affidavit I've given, my lords, one pension. Anyway,
I will consider only your affidavit.
I'll comply. I'll comply.
You have to be fair to your
Please, man.
other side.
Please.
Learned counsel for the petitioner to hand over one full set of documents or along with affidavit which are placed before this, which are filed before this court. Please, parties to address arguments on the next date of hearing. Call on 2 weeks.
Interim order.
Interim order is extended.
Interim was not granted, my lord.
The last date of hearing, your lordship extended it.
Extend.
What is that
It
order?
was granted.
There is no extension.
No, it was not extended, but I will not precipitate the matter.
There is stay of all for the proceedings.
Yes, my lord.
Is the first one. Interim order is passed on 26/9/24 itself.
Please, my lord.
Then it was not extended.
That is why I made a submission before your
Before that,
lordship.
I filed my objection. It is due for hearing. Now the case is there, my lord, on 5th.
For what?
I have made since he did not file assets and liability, I made an application.
All right, we'll
Call for
continue
the
that order.
document.
Work on the order passed by this court on 26/9/24. With regard to stay of further proceedings shall continue till next date of hearing. Please.
Much obliged.
You have to address, we have to resolve this, otherwise there's no point.
That is one reason why today it was posted. In fact, my request to my lawyer to deliver.
All right, now that you know what is required, you can satisfy this court as to how it is maintainable.
Yes, ma'am.
Much obliged.
Right. Pass over ಇದು. ಏನಕ್ಕೆ pass over ತಗೊಂಡ್ರು? And appears when the matter is called for the second time, call next week. Final hearing, you start with final hearing.
Your lordship kindly.
On
Yes,
submission, my lord. Serial number 25, any further date?
25, you want some other day?
Yes.
I'm appearing for the respondent insurance company.
Okay.
Yes.
Then at counsel for the appellant seeks time, call this matter after a week.
Pardon?
Want an adjournment?
When do you want?
15th or 14th or 15th
Call this matter on
or 17th, my lord.
date. Kodi. At request of counsel for appellant.
17th.
Your lordship, I don't have complete case papers in serial number 36, your lordship, so may I request an accommodation?
Request of learned counsel for respondent number 2, call this matter after 2 weeks.
Yes, your lordship.
Appeal memo is given to you?
Appeal memo is there, your lordship. I have asked my company to give because 40% contributor negligence has been considered by the tribunal, which has been challenged here.
All right. Madam, in that other case, have you gone through that judgment?
Yes, your lordship. I've gone through it. That there they have not mentioned the reasons why that has been 50% has been considered is on my submission, your lordship. The other one is that no reasonings are forthcoming in that case, and they have not laid down any precedent in that case, your lordship. Under what circumstances they have taken 50%, that also is not forthcoming in that judgment, your lordship. My submissions are that in any judgments, for that matter, with all due respect to all the courts, your lordship, the judgments which are supported with some reasoning, they have to hold good in your lordship in while discharging a case, disposing of the matter, your lordship. So in that view of the matter, I am of the view that my submission, your lordship, that since no reasoning is forthcoming, no facts are also forthcoming, under what circumstances they have held that 50%, absolutely nothing, your lordship.
So I will take this as your argument.
Yes, your lordship.
Article 142.
True, your lordship. Even then, at least a couple of sentences would have been.
Supreme Court
held
need not say.
Yes, your lordship.
So
But
that's
at the same time,
the difference between ratio decidendi and
yes, your lordship, I
obiter
have
dicta.
gone through that.
Obiter dicta is different.
Yes, your lordship.
Ratio decidendi is
True, your lordship. But in that view of the matter, lordship, my humble submissions are that if that were to be there, they have not laid down any precedent also. We can at least, if the facts were to be culled out in detail, little to some extent, in this Honorable Apex Court judgment, it would have been helped us also whether to canvass that Manavalgan case or not, your lordship. Even that is also not forthcoming in the case.
All right.
Yes, your lordship.
With your lordship's kind leave.
Yes.
My lord, serial number 48 in the second list, my lord. I have filed the memo for dismissal of the appeal as withdrawn. Can order be passed in that case, my lord?
ನೀವು appellant respondent?
Appellant, I am the appellant.
All right. Memo is taken on record, appeal is dismissed.
And amount in deposit may be transferred to the tribunal, if any. Well, amount illa, sorry, we have not deposited the amount.
No, no, which serial number?
48 in second list.
First list. ನೀವು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬೇರೆ ಯಾರ್ದೋ ನೀವು ವಿಡ್ರಾ ಮಾಡಿಸ್ಕೊಂಡು ಹೋಗ್ತೀರಾ?
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. one minute, madam. 230 madam, madam. I'm sorry, 230 madam. First list only, correct.
48 madam, correct ಇದೆಯಾ? Okay, memo is filed. Memo filed is accepted, appeal is dismissed as withdrawn. You are the appellant insurance
Yes,
company?
my lord. Yes.
What happens to the amount?
Amount, my lord, I think we have not deposited because in the claimant appeal, my lord, we have settled the matter by enhancing the compensation. That is MFA, my lord, 4020/23.
No, that is not here, no, before this court.
Yeah, that is not here, but that is the appeal is before the Lok Adalat, and we have got it settled.
So in the appeal which you have filed, you have not deposited any amount?
No, my lord.
All right, appeal is dismissed as withdrawn.
Highly obliged.
ಮೇಡಮ್ ನಮ್ನ ರೀಚ್ ಆಗತ್ತಾ 70 ಆಗತ್ತಾ? ಹಾ
May I make one submission, my lord?
Yes, sir.
My lordship, list number 1, serial number 2, ಬೆಳಗ್ಗೆ ತಾವು ಪಾಸ್ ಓವರ್ ಮಾಡಿಸಿದ್ರೆ ಚಂದ್ರಶೇಖರ್ ಅವರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು ರೆಡಿ ಇದ್ದೆ. ಬಟ್ ಅವ್ರಿಗೇನೋ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದ್ದ ದಯವಿಟ್ಟು ಒಂದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಕೊಡ್ಬೇಕು ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಅದನ್ನ ಆಂಟಿಸಿಪೇಟ್ ಮಾಡಿ ನಾವು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಗೊತ್ತಾಗಿಲ್ಲ ನನಗೆ. ಸಾರಿ.
120, 130 ಕರೆದ್ಬಿಟ್ಟು
ಸರಿ ಮೈ ಲಾರ್ಡ್,
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಏನ್
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗಿದೆ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಆಯ್ತು ಸ್ವಾಮಿ, ಒಬ್ಲೈಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
My lord, CA number 1, my lords, there is minor objection in that. In seeking for direction of this honorable court for speedy disposal, my lords, because of medical, my lords, the petitioner is going through some medical emergency, my lords, because of which we are before this honorable court, my lords. Office objection minor ಇದೆ, my lords. Meanwhile, I will comply, my lords.
ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ, my lords, ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಿ.
So you're seeking mandamus for speedy disposal.
Please, my lords.
On what ground?
My lords, medical ground, my lords,
What has happened to him?
spinal, my lords, spinal problem ಇದೆ, my lords.
Spine.
Spine. Annexure D, my lords, page number 31, my lords. Surgery suggest ಮಾಡಿದ್ದಾರೆ, my lords. Hence, my lords, even cross examination ಅಂತ drag ಆಗ್ತದೆ matter. By my lords. In similar circumstances, my lords, this honorable court has granted the.
When is the petition filed?
My lords, it is on 1/2/2023, my lords. And it's been 2 years.
What is the stage now?
Now it is cross of PW1, my lords.
State defense objections have been filed, statement of objection.
Please, my lords.
Now evidence of your party is over.
Chief is done, my lords. Now
To cross-examine.
cross-examination, my lords.
You rectify the objection.
My lords, I will comply now itself, my lords.
But learned counsel for the petitioner is permitted to rectify the objections during course of the day. Objections raised at serial number 2 is overruled. What is the provisions of the act? Does it say anything for speedy disposal?
My lords, as far as provision does not
Does
say
not
anything.
say.
My lords, the judgment of this honorable court, my lords, which is annexed in annexure D, my lords, which is at page number 36, my lords. This honorable court issued a direction to all the courts for speedy disposal of matrimonial cases within 1 year, my lords.
Hindu Marriage Act. But what does the act say? Provisions of the act, there must be something they can't. What is the intent of the act also? ಓದಲ್ಲ ನೀವು. You don't read and come. Read 21B of the Hindu Marriage Act. Markod. This petition is filed by the petitioner husband seeking a writ of mandamus for expeditious mandamus for a direction to the family court to dispose of the matter expeditiously in the matter pending in MC4 of 2023. Full stop. This court is not inclined to issue notice to the respondent as no adverse orders is passed against the respondent. As direction is being given to the learned judge of the family court to expedite the proceedings. Full stop. It is the contention of learned counsel for the petitioner that the marriage between the petitioner and respondent was solemnized on 28/4/2013. Two children are born from the marriage. But due to disharmony and misunderstanding between petitioner and respondent for 9 long years, a petition for divorce came to be filed by the petitioner husband in MC number 4 of 23 under section 13(1) within bracket Roman 1A of Hindu Marriage Act. Full stop. It is further contended that in the said proceedings, the respondent entered appearance on 28/7/2023 and he has adduced the evidence after the objections to the main petition was filed by the respondent wife. Despite several adjournments being granted, no progress is made in the petition. The matter is now set down for cross-examination of the petitioner witness within brackets PW1. It is contended by learned counsel for the petitioner that the matter has been prolonged and protracted for no reason whatsoever. It is also vehemently contended that the petitioner is undergoing medical issues and has been advised to undergo surgery. And the pendency of this matter is causing more agony to the petitioner. Hence, the present petition is filed for expeditious disposal of the matter in MC number 4 of 2023, pending on the file of Senior Civil Judge JMFC Krishna Rajapete Mandya, Family Court. It is Senior Civil Judge, not Family Court.
Additional Senior Civil Judge, my lords.
All right. Admittedly, the provisions of the Act are clear with regard to the proceedings to be expedited. More specifically, Section 21B of the Hindu Marriage Act deals with special provisions relating to trial and disposal of petitions under the Act. Full stop. Section 21B, subclause 2, reads as, and every petition under this Act shall be tried so and so extracted. In view of the above said provision, the intent of legislature and the proceedings in the matrimonial proceedings relates to the dispute between the husband and wife. The same requires to be decided expeditiously in order to put an end to the ordeal between the husband and wife so that they can proceed further peacefully as early as possible. Under the circumstances, pass the following order. This petition is allowed. A direction is issued to the Additional Senior Civil Judge and JMFC KRPT to expedite the proceedings in MC 4 of 2023 within an outer limit of 8 months.
My lord, 6 months, my
All
lord.
right, 6 months from the date of receipt of copy of the order. When is it posted now?
It is on 7/2/2025, my lords.
You rectify the objections.
Please, my lord.
You paid the court fee.
Please, my lords, I've paid.
Second time, 2 and 3.
Serial number 3.
2 weeks. 2 weeks.
2 weeks.
2 weeks granted to rectify the objections. Yes.
10 days, serial number.
4 and 5. 2 weeks. 3 weeks, Madhima. 4 and 5, 3 weeks.
Appearing for the petition.
Serial number 6.
Lordship, a day may be granted for.
Huh?
A day may be granted for.
A week's time granted to rectify the objection. Yes. Next. Yes, any dispensation? Otherwise, all notices to be issued.
Serial number 7.
ಯಾವುದು?
7 serial number.
ಯಾರಿಗೆ?
R2 ಗೆ.
Notice to R2 is dispensed. Memo is accepted. Issue notice to other respondents.
Serial number 18.
18.
R1.
Notice to R1 dispensed. Issue notice to other respondents.
Serial number 23.
Yes.
R2.
Notice to R2 dispensed.
Then my lord, serial number 40.
Ah,
Respondent number 1.
notice to R1 dispensed. What about 36?
36, my lord, kindly post along with MFA number 3974 of 24.
Call along with MFA 39.
74 of 24.
74 of 24. All other matters issue notice to respondent.
My lord, in this case, my lord, it is, my lord, 2 client petitions, which is, my lord, filed by the deceased of the parents, my lord, that came to be allowed by the trial court. And also they have prepared an appeal also disposed by NHD compensation. Now, my lord, in this case, the client petition came to be dismissed by the trial court.
Notice ತಗೊಳ್ಬೇಕಲ್ಲ.
Mm,
You have to take out notice to R1.
My submission, my lord, is that, my lord, is this appellant, my lord, is the pillion rider.
Hmm.
My lord, the court has given the finding that, my lord, he himself is the owner of the vehicle. That pillar, the court not granted any compensation, but he is, my lord, my claim is that, my lord, against the offending vehicle, my lord. The trial, there, as on the date of the accident, my lord, there is a policy, the offending vehicle.
Liability is fixed against the offending vehicle.
Before, in connected against the, my lord, company, my lord.
Offending vehicles, then the insurance company.
Please,
So you are pillion rider.
I am the pillion rider.
Those
Rider is the deceased, my lord.
Those petitions are allowed.
One is death case is allowed. This injured case is claim came to dismiss, my lordship.
All right, you have to take out notice. Notice ತಗೊಳ್ಬೇಕಲ್ರಿ.
My lord, what my submission is, my lord, notice is, because as on the date of the accident, my lord, policy is in force. My lord, even the, my lord, in the connected, my lord, the MFA, my lord.
Don't you think the other side will have to have a say?
I have furnished the details also, my lord. Sri D. Vijay Kumar.
He is appearing for R1.
Please. No, R2, company, my lord.
Who's R1?
R1 is the owner of the vehicle, offending vehicle.
So liability is fixed against the insurance company.
Insurance company, in that case, my lord.
So whether R1 is required in your case?
In your case, my case, my lord, as per the documents, my lord, the notice is not required, my lord. Anyway, my lord, claim petition can be dismissed, but my lord, policy, permit, FC, everything is, my lord, as on the date of, that's what.
All right, you take out notice. Where is Mr. Vijay Kumar? Let him file wakalat. Please. A week's time granted for petition appellant. Do the needful. If same is done, issue notice for R1.
Already matter.
Meanwhile, you produce those judgments of that.
Please, my lord.
My lord, 2 weeks time to file wakalat, my lord. Earlier advocate, my lord, P. Shikumar is no more, my lord. Hence, 2 weeks time.
Who are you?
I am appearing for, I will file wakalat, my lord, 2 weeks time.
For whom? For Supreme?
For appellant, my lord.
Appellant, what's your name?
Raghu R.
Shall I show your name?
Yes, ma'am.
Registry to show the name of learned counsel Raghu R.
Yes, ma'am.
For appellant. What about this delay?
32 days delay.
All served. Ibrina,
Yes, my lord.
IA 1 of 23 is allowed delay of 34 days in filing the appeal is condoned. Yes, call after 2 weeks.
Much of.
Nagaraj Reddy, R2 notice.
For appellants only. Press 1 week times only.
Respond number 2, my lord. Today copy served, my lord. Next week's time.
Counsel for R1 acknowledges the receipt of copy of the appeal memo. A week's time is granted. If needful done, issue notice to R2. So also R4. Yeah, it's 2 and 3, 4 and 5.
For the appellant. Point number 1 get dispensation notice.
Notice to R1 is dispensed.
Delay 208 days.
IA 1 of 23 is allowed. Delay of 208 days is condoned. However, your claimant,
Claimant.
no interest for the delayed period. Week's time, needful done, issue notice. Same order.
Connected matter, my lord, I filed an application for withdrawal of amount. Notice to R1.
Notice to R1 is dispensed. Who's R2?
R2, my lord, Oriental Insurance Company.
Sheshagiri.
Geeta Raj is appearing, ready.
Huh?
Connected matter, my lord, Geeta Raj is appearing.
In 45, we are appearing.
45.1 al nevidira.
Please, Geeta,
File that appeal.
please, my lord. We are,
So you
Filed
take
on-
notice for R2 in his case.
please, my lord.
R2 is
We'll take notice
please.
in 45
insurance
point.
company.
Please.
Please.
Learned Counsel Sri Mati Geeta R is directed to take notice for R2. Registry to delete the name of YK Seshagiri Rao from the cost list and show the name of Learned Counsel Srimati Geeta R.
In 45, 39 days delay may be condoned.
All right, 45.1, IE 1 of 23 is allowed delay of 39 days is condoned. What about withdrawal? Any objection?
That's why I questioned on the quantum. 50% of the deposit may be.
Quantum, why 50%? Let them withdraw entire amount.
They have
You have deposited 50%.
Please, my lord.
Please.
In that 50% may
IE
be allowed.
IE 1 of 24 is allowed. Respondent claimant is permitted to withdraw the amount deposited by the insurance company. Where have you deposited?
Before this court, ma'am.
Registry of this court is directed to release and disperse the amount deposited in favor of the respondent claimant upon proper identification to electronic transfer to the account of the respondent upon furnishing proper details.
Please. Much of.
Grateful.
Records are required?
Please.
Secure records.
Paper 1 week time.
Harish, 2 weeks?
Paper 1 week time.
Weeks?
1 week time.
A week's time granted to do the needful.
This for R2, Your Worship, Pradeep may be directed to take notice for Bajaj.
Bajaj Alliance, huh?
Yes,
Yes,
Pradeep.
you're on panel for Bajaj? Learned Counsel Pradeep B is directed to take notice for R2. Registry to show his name in the cost list. What about 3?
You have to take first steps, Your Worship.
A week's time granted, if needful done, issue notice to R3. Two weeks time granted, to do the needful. Needful done, issue notice. What is the connected matter? Paper publication?
Appear for the appellant, my lord. 49.1. The paper publication ಹಾಕೊಂಡಿದ್ದೀವಿ. ಅಯ್ಯೇ ಅಲ್ವಾ?
ಯಾರಿಗೆ ತಗೊಳ್ತೀರಮ್ಮ?
R3 is owner of the vehicle.
Learned Counsel for the appellant in MFA 507 has filed an application under Order 5 Rule 20 to take out notice through newspaper publication to respondent number 3. Full stop. Peruse the affidavit annexed to the application, being satisfied with the same and regular notice having not been served or received, his application is allowed. The appellant is permitted to take out notice to R3 by way of substituted service through newspaper publication in Sanjay Vani daily newspaper, Kannada daily, alla? Kannada daily newspaper of Bengaluru edition. The publication shall be taken
For appellant, my lord, on behalf of Pingraju, sir, I am representing, my lord. Press week's time, my lord, to take
Week's
steps.
time
number one,
granted if needful done issue notice.
I have deposited before tribunal, my lord. I will
Counsel
produce
is-
acknowledgement.
For the appellant submits, he has deposited the award amount before the tribunal.
Please, my lord. Much obliged.
I appear for appellant.
Ah.
Last occasion I came little late, by the time the case was called and notice has been issued. IA1 is pending. For
IA?
stay. IA1 for stay.
Stay na?
Yes,
New Year game. Insurance company.
insurance.
A week's time granted if needful done issue notice to respondents. In the meanwhile, no delay.
Noted.
There shall be stay of operation and execution of the order dated 7/8/24, MVC 1192 of 23. Passed by Motor Accident Claim Tribunal, Senior Civil Judge Sulia. DK, subject to the condition the appellant deposits 50% of the award amount within 4 weeks for the tribunal.
Yes, ma'am.
On such deposit, same shall be kept in a fixed deposit in a nationalized bank.
For the appellants, my lords, kindly 2 weeks of time may be granted, my lords. 52.
What is this, Mr. Bhandari?
Please, your worship. One, I am referring, your worship. I have filed the paperwork. They have filed the paperwork. Now, by virtue of the subsequent development, your worship, the suits are, both the suits for injection, your worship. Both the suits are rejected. Against which RS is filed now, your worship. Now, his claim is for your.
Both the suits are
For
rejected. Both suits are rejected.
Yeah.
So you are the plaintiff.
One case, my case, I am the plaintiff, in their case, they are the plaintiff. Suit and counter suit for grant of injection. And your lordship, if an area also it was rejected, then RS. During the pendency of this RS, your lordship, now whatever the Tahsildar has quoted the land and identified the land. According to that identification of the land, your lordship, no land is left out for the defendants. That is the another suit.
After Podi, what he has done?
Four
Yeah,
of the land.
After Podi, what has happened?
The land was quoted and it was bifurcations. and-
All right, after that?
Boundary mark.
Ah.
Tahsildar has taken place, your lordship, that has been taken place.
Ah.
During condition of this appeal.
Ah.
Now, no land is left out in this name, your lordship.
Ah.
So that I have likely to produce, your lordship. So, in the absence of such a day, when there is no land or no possession is in him, in the absence of such no possession, without seeking the declaration, probably his suit is not maintainable.
Suit is filed by him for what?
For permanent injunction, my lords.
Injunction,
Permanent injunction.
permanent.
All right, but that has to be decided.
Yes, ma'am.
But ಈಗ subsequent development ಆಗಿರೋದ್ರಿಂದ ಅವ್ರು ಇಲ್ಲ.
You are now in possession. We enjoy the position, we'll decide the matter on merits. It has to be decided nevertheless, it's the second appeal now. So that already must be an issue decided by both the courts. And subsequent, now who has ordered that 4D to be done?
Now your worship, Tahsildar has done, your worship.
So before, there was no stay.
No, there's no stay.
So your suit is now, you are successful because of this.
Because of that subsequent,
Now her suit is dismissed.
has to be dismissed now.
And her suit was already dismissed by the trial court.
Both the suits are dismissed. One filed by me against him and another filed by them against me. Claiming in the same property.
And first appeal also both
Both.
came to be affirmed.
So both of us filed the.
All right, now after that, both of you are before this court. Then how did the revenue authorities start taking action for Podi?
Because by the time your lordship, there was a applications were pending before the court, Tahsildar office.
Before?
Tahsildar office and to the, for
Before.
demarcation and bifurcation of the lands.
So he has continued with that
Continued with
because there was no order granted by this court. That's the only thing now you have to address.
Yes, my lords, I'll seek instruction, my lords.
Just land extent, extent,
1 acre.
agricultural land.
Kindly 2 weeks may be granted. my
All right.
lords.
2010 RSA, the suit is of which year?
My suit is your lordship. 96.
Years, I.
Otherwise, your lordship, both, it is anyhow, it is a recurring cause of action. The injection is the recurring cause of action. Both the suit has to be, both the appeals has to be.
Both suit has to be disposed.
Yes. That may be this.
So now after the Podi, you have taken possession?
Position, even from the beginning, I was in the position.
Okay.
Only in the entry, it was in the entry, RTC entry, his name was reflected. Taking that count, your lordship, that his name was entering, he was trying to interfere with the position. Ali 14 ಎಕರೆ ಜಮೀನು ಬೇಕು, ಎಕ್ಸ್ಟೆಂಟ್ ಜಾಸ್ತಿ ಆಗಿ ಬರ್ತಾ ಇತ್ತು ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ.
All right. So that's the only short point involved. Yes, who's going to argue? Siddhamalappa
Yes, my lords.
or a learned counsel for the appellant in RSA 2026 seeks time. Learned counsel for respondent is present. Call after 2 weeks. How much time you want next week?
2 weeks, my lords.
Call after 2 weeks. Next.
For the appellants, my lords,
Hmm.
needful is done, my lords.
ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ತೀರಿ ಇಲ್ವಾ? Previous matter, they are supposed to file the paper book, that's why. Okay.
It's again, paper became because. Records ಇರ್ಬೇಕಲ್ಲ ಇಲ್ಲಿ?
Because it is sack paper to discuss.
Madam, records are here?
They have not filed the wakalat also.
Huh? Idea. It is available here. So paper book may not be required in
It
these
may be
cases.
dispensed, my lords.
No, let it be. It may not be required, I think, to consider this.
My cases are filed.
All right.
For the appellants,
Await service of notice.
my lords, in this matter,
Serial number 53, I am
Ah.
for respondent.
Ah,
The appellants are not giving the copies of appeal memo itself.
not giving you.
Non caveator.
I'll serve the copies.
Paper book has been dispensed with and questions of law framed is whether according to section 63 of the Mamdan law, shares have been properly assigned.
I'll serve the copies, my lords.
Question of law is framed.
How?
ಆಗಿದೆಯಾ? What do you want? Madam, you have to give him the paper.
I will serve it today itself, my lords.
Determine the shares, whether the trial court which has awarded the shares, whether it is in accordance with section 63 of the Mamdan law. That's all the point.
Today itself, I'll serve the copies.
Learned counsel.
ಅವ್ರು ಏನ್ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಅಪೀಲ್ ಮೆಮೊ ಅಪೀಲ್ ಮೆಮೊ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
I'll direct them. In 2 days, they'll give it to you.
Yes.
Learned counsel for the appellant to furnish the appeal memo along with documents, if any, within 2 days to learned counsel for caveator respondent number 1, 2, 5, 6. Yes. We'll list next week.
My lords, appellants in this matter, my lords, I filed the application to bring a loss of respondent number 4, my lords.
Hmm.
Notice will be issued, my lords. Respondent number 4, A to C, my lords.
R4 is dead, is it?
Yes, my lords.
Where is that application? You have filed IA.
Yes, my lords.
Learned counsel for the appellant submits she has filed an application. Bring on record LRs of R4
R4, my lord.
registry to put up the application. All next week.
Obligation.
Weeks, 2 weeks time granted if needful.
My lords, serial number 55, my lords.
Ah,
My lords, I'm appear for the petitioner, my lords. The respondent is already on record, my lords. She has filed the wakalat also. Same has been recorded in the earlier occasion also, my lords.
And for the respondent desire. The cause list is, my name is not listed. The last date also is not listed, today also is not listed.
Please come to the mic and speak.
I filed the wakalat on the 21st of October 2004
name,
for
ma'am?
the respondent. My lord.
What's your name?
Hina.
Kodi birth code. Learned counsel so and so is present. She submits, she has filed wakalat registry to put up the same and show her name in the cost list.
Lords,
Yes.
I praise for a short accommodation, my lords. I will address the arguments. Interim order granted earlier, my lords. That may be extended, my lords.
In the last date,
Last date, my lords.
Non-appearance, my lordship, is interim order not extended.
Kindly, my lords.
2911 is listed before this honorable court. No one has.
What is the interim order?
My lords, trial court has issued an NPW to the petitioner for non-payment of substantial amount, my lords. Substantial amount of compensation, maintenance. That issuance of NPW has been stayed by this honorable court, my lords.
Has he paid the maintenance amount?
Please, my lords.
Outstanding amount it was is the 31 lakhs, my lordship. It is the case from the 2005 old matters. It is his main order is confirmed by the 2022 in this honorable court, my lordship. After that, I filed that recovery suit before this family court. And there it is comes is arise some 40 lakhs something. And he is going to paying that after the receiving that recovery suit notice, and he is going to coming and is filed that modification of the order. That
No,
is
my
his-
lords. I have
that
not.
I-
Kindly see my prayer, my lords.
Wait,
Right.
let her complete.
I'm apologizing, my lords.
What they filed that in the, before making the payment in my recovery suit, they filed that they're seeking the 127+2 for the modification of the order. In that application is not at all order. Any order is not passed. Based on that order, they come and they filed here and they taken the stay. Only they deposited at the time of the, out of 31 lakhs, my lordship, FRW issued against petitioner. And here is only 2 lakhs rupees there deposited, and they are agreed to make the payment is every 30 days. Once in only 60,000.
60,000.
Yes.
How much is ordered?
Order is, it is for the per month till her lifetime 20,000, my lordship. That arrears itself is incurred, it is more than 40 lakhs. When I'm filed that my recovery suit. Since 2005 is struggling.
May I submit, my lords?
Every time.
Yes.
Kindly, my lords, my repetition page 7, my lords. I have detailedly stated whatever the amount which I have deposited by the court and by the way of DD. I have clearly stated in my repetition memorandum, my lords. I will convey the my lords by next date of hearing, my lords. Kindly have it on next week. Kindly, my lords, kindly see my prayer, my lords. What I have stated, my lords, issuance of NBW, that may be, that order may be quashed. And subsequent, consequently, my lords, I have filed one IA in the year 2022 itself, my lords. That IA has not been taken till today. That has been not considered. I'm seeking mandamus to dispose of that IA, my lords.
Which IA?
My lords, I have annexure B, my lords. I have filed IA under section 125 class 5, read with section 127. Annexure B, my lords. Page 34. This IA had filed on 12/10/2022, my lords. This IA till today, the trial court had not considered this IA. The respondent also, they have not filed any objections.
I filed my objection.
Are you paying 60,000 every month?
Please, my lords. Last date only, my lords, I had not paid because, my lords, that before the trial court, The matter was taken up for 2 months gap was given, my lords. That's the reason I had not paid my lords. But till today, including
Here-
20,000 of maintenance amount, my lords, I am paying the 60,000 amount, my lords. Till today.
29/11, it is posted, my lordship, this honorable court, no, none appearance in this matter.
File memo.
Please, my lords, on that day, my lords, I came to the court, my
Here
lords.
there is,
By
that
that
interim
time,
order
the
also
matter
not,
is
not
adjourned, my lords.
extended,
That
and
is the
meanwhile,
reason I have not appeared, my lords.
in the meanwhile, they are not deposited their amount.
My lords, I have deposited, my lords, they have only taken, before the trial court also, they have signed and they have taken the DD, my lords.
And here, in the next hearing date is June, my lordship.
ಆಯ್ತಾ ಆರ್ಡರ್ ಮಾಡಕ್ ಬಿಡ್ತೀರಾ? Learned counsel for the petitioner and learned counsel for the respondent are present. It is the grievance of learned counsel for the respondent that maintenance amount is not paid regularly, whereas counsel for a petitioner submits the up-to-date maintenance amount along with arrears is paid. Under the circumstances, both the learned counsels are directed to file memo of calculation with the details of having made the payment and having received the amount. Full stop. The interim order granted on 1/10/2024 is extended till next date of hearing. Yes, file memo of calculation, how much is paid, how much is not paid.
Obliged, my lords.
Wait.
This matter I appear for the petitioner.
My lord, I appear for respondent. I undertake to file wakalat, my lord. By tomorrow, I'll file wakalat, my lord. Have the matter next Monday, my lord. I'll assist the court.
What is
This
your
matter.
name?
My lord, Siddheshwara B.
Learned counsel Sri Siddheshwara B undertakes to file wakalat for respondent.
Yes, my lord.
Obrena.
Interim order is there, my lords.
Only one respondent.
Yes, my lord. Only one respondent, my lord.
Registry to show his name in the cost list. Interim order is extended till next date. of
My lord,
hearing.
date may be given, my lord.
All after 2 weeks. Gowda.
This case I appear for the, but in this case, claimant number 4 is dead. But R1 to R3 and R5 are the legal representative of the deceased. Therefore, they may be treated as an LRs of the deceased. I may be permitted to amend the class title to that extent right now.
Submission was made last time and it is already ordered.
Please, I may be permitted to.
What is this return of TCR?
Return of LCR. ನೀವು ಹಾಕಿರೋದು.
Anybody is filed for withdrawal of the amount?
We have not served the appeal. It may be posted any next week, my lord, final hearing, we will address the argument on.
Who appears for claimant?
I'm
I've seen
appearing for the
others.
claimant's fund.
You don't know? No.
LCR has filed by them only.
All right. You are already permitted, sir. You can carry out the amendment.
That's what.
Madila amendment.
Madila.
Carry
You
out.
may permitted to do it, right?
Appellant is permitted to carry out the amendment.
Please.
And file amended cost title by serving to the other side.
Cost title is not required.
They
my
appear
lord,
for
because,
respondent number 7.
Huh?
It will not change any, this thing, only cost title, bari our legal representative ಮಾಡವಷ್ಟೇ.
ಅದು ಮಾಡಿ amendment ಹಾಕ್ಬೇಕಲ್ಲ.
Dispense ಮಾಡ್ಬೋದು. Please.
File ಮಾಡಿ. Only the cost title you file.
Only cost title.
You need not file the entire appeal.
Please.
What is the next one in the crop?
Crop, my appeal, my lord. Respondent number 3 direct ಮಾಡಿ ನೀವು ಎಷ್ಟನೇ respondent?
Number 7.
ಅದ ಓನರ್ಗೂ ಡ್ರೈವರ್ ಓನರ್. Respondent number 2 is the owner, my lord. Directed to take notice and respondent number 3 also.
I'll take.
Respondent number 1.
Learned
notice, my
counsel
lord.
Sri B.C. Shivannagowda is directed to take notice for respondent number
3, my lord.
3. And learned counsel
Res-
Suyoga.
Please, my lord.
Yog Herele E is there to take notice for respondent number
7.
2, ನನ್ನ
2.
issue notice to respondent number 1, my lord.
She notice to R1. What about 4?
4 already.
Deceased petitioner 4,
Deceased.
Imparty,
ಮಾಡಿದೀನಿ ಸುಮ್ನೆ ನೋಟ್ ಹಾಕಿದೀನಿ ನನ್ನ ಅಪೀಲ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ.
that he is dead anta.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Note filed by the appellant below the cost title is accepted. So others are the legal
ಎಸ್
LRs
ಎಲ್ಲ ಎಸ್ ಮೈ
as what he has said. List on. Next week,
Any day. I'm ready.
2 weeks. ತಗೊಂಡ್ರಲ್ಲ ಅವ್ರು.
Copy may be furnished.
R1
Okay, R1 is steps.
ಆರ್ವನಿಗೆ ಸರ್
Who's R1?
ಡ್ರೈವರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್ ಮೈ ಲಾರ್ಡ್.
ಯಾಕೆ
Why is
ನೀವು ಅಪೀಲ್ ಹಾಕಿದಾರಲ್ಲ ಅದ್ರ ಲಕ್ಷಕ್ಕೆ ಅಂತ ಇದೆ.
Driver ಮೇಲೆ ಏನ್ liability ಇದೆಯಾ?
ಓನರ್ ಇಸ್ ಓಕೆ ಡ್ರೈವರ್ ಯಾಕೆ ನಿಮ್ಗೆ?
ಐ ವಿಲ್ ಫೈಲ್ ದಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೋ ಮೈ ಲಾರ್ಡ್. ಅವ್ರದ್ದು ಅಪೀಲ್ ಇತ್ತಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
File now only, madam. Why this already old matter 21.
ಎಸ್ ಮೈ ಲಾರ್ಡ್ ಟುಡೇ
Memo
Dispense
ಕೊಡಿ. Memo. Notice to R1 is dispensed, memo accepted. No liability against driver.
ಡ್ರೈವರ್ ಮೇಲೆ ಬರಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಬಂದ್ರು ಓನರ್ ಮೇಲೆ
ಮಾಡ್ತೀವಿ
ಬಂದು
ಇವಾಗ driver.
therefore
Driver also should be liable when he is driving rashly.
driving license.
Should fix it on him so that he is now, everybody becomes careful.
Please. Maybe.
Ganapati.
ತಂದಿಲ್ಲ ಸರ್.
And taxi counsel appear for this case. My friend is held up in some other courts. Kindly give a notice issue to
Ganapati.
substitute company.
For Ganapati you are appearing. Ganapati,
Ganpati is held up in some other court.
substitution in respect of proposed R3.
It's R3, before the tribunal matters was Bharti Exar General Insurance Company. Now it is merged with Mallard's ICICI Lombardo, General Insurance Company.
ಅದನ್ನ substitution ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Substitute company, no substitute.
So Bharati AXA General Insurance Company is now merged with ICICI.
Yes, miss. ICICI Lombard General Insurance Company.
So that can be done.
Yes, miss.
You are appearing?
For respond number 3 minutes, proposed.
ಇಲ್ಲ substitution ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರನ್ನೇ for R3 you will appear.
Yes, yes.
Learned counsel for the appellant has filed IA number 1 of 24, seeking substitution of respondent number 3. I have perused the affidavit, memorandum of facts and the application. Being satisfied with the reasons assigned and cause shown, and in view of the fact that Bharati AXA General Insurance Company Limited has been merged with ICICI Lombard General Insurance Company. ICICI Lombard General Insurance Company. The application is allowed. R3 petition, appellant is permitted to carry out the substitution process of R3. R3 shall be substituted as ICICI Lombard General Insurance Company. Learned counsel Shri Ashok Patil takes notice for R3. Copy is received.
Yes, miss. I have filed my wakalat also.
You proposed to ಹಾಕಿದ್ರಿ ಇವಾಗ this R3 ನೇ substitute ಮಾಡಿ
Yes, yes.
You remain R3 on. Yes.
May we refer to Lok Adalat?
At request of both parties, matter is referred to Lok Adalat.
Please.
Ananta Krishna Bhatt.
Again for the exponent number 1.
Claimant appeal memo.
So I have received the appeal memo about 2 days back. I have to take instructions from the insurance company and file the wakalat. We'll have it after 2 weeks.
I'll allow the IA.
My name is there because I not filed the wakalat.
Learned counsel for
Around 2 weeks on the I filed the wakalat and I'll.
appellant and respondent are present. Counsel for respondent seeks time to secure instructions called after a week. Yes, after a week.
Please.
Swami. AE 1 of 24 is allowed, delay of 133 days is condoned. Yogesh. Issue notice.
Appellant Miller.
Same.
Owner liability Miller.
Issue notice. Your claimant.
Yes, Miller.
Notice.
63 also Miller.
Also.
Same
Claimant.
Miller. Ah.
Issue notice.
Claimant.
Gurudev. Notice to R214 dispense 1, 3. A1 of 24 is allowed delay of 34 days in filing the appeal is condoned. Dabali. Issue notice pending consideration of IA1 for delay. IA2 is taken up. That shall be stay. Order dated 20th September 23, MVC 297 of 17, asked by Senior Civil Judge and JMFC Additional MACT Channapatna, subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from today.
It is a driver's appeal, my lord. The motor vehicle owner's minute, the liability was fixed on.
Whose appeal?
Driver appeal, driver.
Email hakidara.
Driver may access because it is wrong. Only the arrest notice was issued against the owner and driver, my lord.
Owner and driver mail.
Yes, ma'am. I am a driver, my lord.
Issue notice pending consideration of IA for delay. There shall be stay. Order dated 7/3/24, MVC 556 of 23, passed by Principal Senior Civil Judge JMFC MACT at Sagar, subject to the appellant depositing.
No, my lord, thing is that already 25,000 deposited here.
How much?
25,000 deposited here, my lord. I am a driver, my lord. I am not liable. I am the driving in the, suddenly pedestrian came to the middle of the road. Yes, my lord, I am a driver. I am a daily wage worker, my lord. I could not already.
ಏನ್ ವೆಹಿಕಲ್ ಓಡಿಸ್ತೆ?
ಬೈಕ್ ಸ್ವಾಮಿ, ಬೈಕಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದು, ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೆ, ಸಡನ್ ಆಗಿ ಬಂದ್ಬಿಡ್ತಾರೆ. ಇದೆ ದ pedestrian. 1,60,000 was awarded.
Want this appeal to be considered, you have to deposit.
No, madam, I am a driver, madam. It is the owner is not appearing in the court, madam. It is only, I only appearing. Against the owner and me, owner was not appearing in trial court, madam, in present.
He was placed absent.
Yes, madam. No, earlier he was appeared. And this is the ex parte, madam. Page number 7, my lord. 9, 7 minutes, sorry. 9. He was ex parte, my lord. In execution also, present also is not appearing, my lord. Only driver only appeared, my lord. Award passed against me and owner.
What happened to the notice? You have to now take out notice.
No, I have taken the notice, madam. In the
Take out notice, you
no, madam, in
deposit.
the meanwhile, arrest notice was issued in trial court, madam.
Huh?
Arrest notice has been issued, madam, against me.
Then you deposit some amount.
No, madam, I was a daily wage worker, madam. I could not deposit even.
ನಿಮಗೆ ಏನೇನು ಎಕ್ಸಂಪ್ಷನ್ ಇದೆಯಾ? ಡೈಲಿ ವೇಜ್ ವರ್ಕರ್ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಅಮೌಂಟ್?
Kindly see that, my lord. May I read it, my lord? Page number 10, my lord. May I read it, my lord? Paragraph number 6, my lord. The last line, my lord. Then
How much you will deposit, sir? I'm not interested now. How much
Yeah.
you're going to deposit?
Already, my lord, this before this court, 25,000 has been deposited, my lord.
Subject to the appellant depositing 25% of his share within 6 weeks from the date of receipt of copy of the order. Sashidhar. You notice pending consideration of I1, there shall be stay. Order dated 21/6/24, MVC 173 of 23, passed by First Additional Senior Civil Judge, Additional MACT 4 Chitradurga. Subject to the condition the appellant deposits 50% of the award amount. Within 4 weeks before the jurisdictional tribunal. Issue notice stay.
Liability is in dispute. There is a delay of 104 days. Meanwhile, they have filed an execution.
Order
execution
dated
26 of 24.
6/5/24, MVC 15 of 22, passed by First Additional District Judge, MACT Kodagu. Subject to the condition, the appellant deposits 50% of the award amount within 4 weeks before the tribunal.
Tribunal.
The appeal. I'm ready to deposit entire amount of 50,000. The act only policy matter, occupant of in a private car, risk is not covered. The tribunal without considering the defense liability fixing.
Issue notice pending consideration of I1, shall we stay? Operation and execution of the order dated 20th March 24, MVC 558 of 18. Senior Civil Judge, MACT Kundapura, subject to deposit of the entire award amount, which shall be kept
Bank.
deposited before this court.
Yes. The memo for dispensation for second respondent is the driver of the car, my lord.
Notice to R2 is dispensed. Issue notice to R1 and 3.
Respond by me.
Serial number 70.
Yes, 70.
I appear for the petitioner before this honorable court.
Objection filed.
Lord, by the order dated 10th of April 2023 at page number 14. This honorable court has passed an order in respect of a writ petition filed by Srimati Shobha, Bhagya and Katama. Believing their submission to be truthful, believing themselves to be the legal representatives of the petitioner herein, who is dead at that point of according to them. Kindly see paragraph number 2. They made a false representation before this court and obtained an order by commission of fraud. Paragraph 2 of the order, which your lordships would find it page number 16, internal page number 3. May I read the relevant portion?
Yes.
Petitioners 1 and 2 are the children of late Chinnappa. Kindly mark this, late. Petitioner number 3 is the wife of late Chinnappa. Sri Chinnappa was the only son of so and so, so and so. That is not been disputed. But they claim that they are the legal representatives, though they are the strangers, and they claim that the petitioner is dead. And they produce even the death certificate before this honorable court by creation of death certificate, which your lordships would find it at page number 56. Kindly see page 56. This is a fraud played on the court itself. And the petitioner is very well present before this court now.
Page number
56, Annexure D, which I have filed along with the IA for production of additional documents now. Do you lordships have that death certificate issued by the government of Karnataka?
Yes.
Yes, kindly see here, my lord, they claim that 30/12/2012, the petitioner is dead.
Yes.
And based on that document, They claim that they are the legal representatives, though they are the strangers. They claim the right over the property, and they seek a writ of mandamus. Kindly see the order passed by this honorable court, which you also find at page number 14 again, at the cost of repetition. Do you also have that order below, passed by this court? Internal page number 5, paragraph number 18. Para 5, paragraph number 5, page number 17, which you will also find it at the left hand side. This being the state of affairs after the death of Badiyappa, only son Chinnappa, having succeeded in his estate, has become the successor and absolute owner of the land. The khata was ordered to be transferred in his name, but unfortunately Chinnappa died on 30/12/2012, leaving behind his wife and children who are the petitioners before this court. And para 6, pursuant to the death of so and so, petitioner approached the responsible to effect the khata of the property in question to their name jointly, and the same has not been effected by the response number 3 Tahsildar. Thereafter, the petitioners approached the superintendent of police so and so. Thereafter, Assistant Commissioner, video order dated so and so, director response number 3 to take immediate action regarding restoration of the land in favor of the petitioners after obtaining the legal opinion which is endorsed as an exterior. Para 7 is important. It is the contention of the learned counsel for the petitioners that despite the lapse of more than 2.5 years, the respondent number 3 Tahsildar has not taken any action pursuant to the order at Annexure B and effect khata of the said property in favor of the petitioner. The said proceedings of the respondent number 2/Assistant Commissioner came to be dismissed and an appeal preferred by the aggrieved person before the Special Deputy Commissioner, which is also came to be dismissed. And thereafter, the writ petition also came to be dismissed, and also the writ appeal preferred by the aggrieved persons. Hence, it is seen that the entire transactions are culminated into finality. Now, kindly see para 9 is quite relevant. It is the duty of the respondent number 3 Tahsildar to pass an order in accordance with law. He could not sit over the matter according to his whims and fancies without passing any order. He can't run away from the taking action in accordance with law when the petitioners have succeeded in all the forums. It is apparent that there is clear negligence and dereliction on duty in non-compliance of the order dated so and so passed with the respondent Master Commissioner and hence previous order stated above. In these circumstances, in view of the discussions made above, I proceed to pass the following order. The writ of mandamus is issued to the respondent also to immediately pass appropriate orders with regard to so and so to an extent of 2 acres to be restored in the names of the petitioners, and also to restore the khata entries and other revenue entries in favor of the petitioners forthwith within a period of 4 weeks from the date of receipt of the copy of this order. If the same is not done by the respondent number 3 Tahsildar within the time limit prescribed by this court, respondent number 3 Tahsildar should have to pay the cost of rupees so and so personally, and the matter shall be referred to the higher authorities to initiate action against him for not doing his duty in accordance with law. For a moment, I am not finding fault with the observations made by this court. But this court was misled. This court was misdirected based on a fraudulent document. And this court, in the normal course, could have considered these documents without examining the validity or the legality or genuinity of the same and proceeded to pass on. So, may I submit below? I'm sorry.
Yes.
Yes. In this case, my lord, this is a clear-cut case where they have taken the court for ride. This is purely an abuse of the process of court. And kindly see the documents which are placed. There are certain documents which clearly demonstrate how the fraud was played. Kindly see annexure page number 51, which I have produced before this court. This is the Aadhaar card of the petitioner. Petitioner is before this court now present.
Where is he?
He was in the court hall, my lord, few minutes ago. And this is the Aadhaar card of the petitioner, which you will also should get it at page number 51.
In the Mesreno. Chinnappan. ಎಷ್ಟು ನಿಮ್ಮ ವಯಸ್ಸೆಷ್ಟು? ವಯಸ್ಸೆಷ್ಟು?
74 ನಡೀತೆ.
ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಏನು?
ಇದು ಐವತ್ತು ಎರಡು ನಾಲ್ಕು ಎರಡು ಇದೆ ಸರ್ ಡೇಟ್ ಆಫ್ ಬರ್ತ್.
50ನೇ ಇಸ್ವಿ, 2ನೇ ತಿಂಗಳು.
ಎರಡನೇ ತಿಂಗಳು.
ಡೇಟ್ ಗೊತ್ತಿದ್ಯಾ?
ಆ ಡೇಟ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ.
May I take your losses to page number 52 if your losses could kindly permit me to take further?
16ನೇ ತಾರೀಕು ಸರ್.
ನಿಮ್ಮ ತಂದೆ ಹೆಸರೇನು?
ಬಡಿಗೆಪ್ಪ.
ಇವಾಗ ವಯಸ್ಸು ಎಷ್ಟಾಗಿದೆ ನಿಮ್ಗೆ?
ಸರ್
ಇವಾಗ ವಯಸ್ಸು ಎಷ್ಟಾಗಿದೆ?
ವಯಸ್ಸು 74.
ಮದುವೆ ಆಗಿದೆಯಾ ನಿಮ್ಗೆ?
ಆಗಿದೆ ಸರ್.
ಹೆಂಡತಿ ಮಕ್ಕಳು ಇದ್ದಾರಾ?
ಇದ್ದಾರೆ.
ಏನ್ ಹೆಸರೇನು?
ನಾರಾಯಣಮ್ಮ.
ಮತ್ತೆ
ಮಕ್ಕಳ ಹೆಸರು ನಾಗರಾಜು, ಪ್ರೇಮ್ ಕುಮಾರ, ಮಂಜುನಾಥ, ಸುರೇಶ್, ನಂಜಮ್ಮ. ಹೆಣ್ಣು ಮಗು.
ಮನೆ ಎಲ್ಲಿರೋದು?
ಹೆಣ್ಣೂರು ಸರ್.
ಮನೆ ಮನೆ ಮನೆ
ಮನೆ ಹೆಣ್ಣೂರು ಸ್ವಾಮಿ.
ಹೆಣ್ಣೂರು. ಅಡ್ರೆಸ್ ಗೊತ್ತಿದೆಯೇನೋ?
ಹೆಣ್ಣೂರು.
ಅಡ್ರೆಸ್ ಇದೆಯಾ?
ಅಡ್ರೆಸ್ಸು ಹೆಣ್ಣೂರು ಸ್ವಾಮಿ. ಇದು ಕಲ್ಯಾಣ ನಗರ ಪೋಸ್ಟ್ ಬೆಂಗಳೂರು 43.
All right. Yes, what else you want?
Page number 52, I was driving losses to page number 52. May I continue to submit, Melo?
Yes, yes.
Page 52 is the voter's ID. And page 53 is family tree by way of an affidavit of the petition.
All right, who are these people who came before the court?
They're strangers. That precisely, it is a case cooked up by the land mafia. That's all I would say.
All right, pursuant to the order passed by this court, anything has happened?
Yes, my lord. That's what is the case here now before this court. Now they are changing the entire revenue documents in favor of the petitioners there. And they have taken already an action. And they are not entertaining the petitioner. They say that you are already dead as per the records. As per the order of the court, more so. I'm sorry to say, submit before this court. Because since there is already a recording, they do not, there is a recording in the order that the petitioner is dead and they are their legal representative. They are not even ready to entertain our applications.
All right.
So, my lord, firstly, my submission would be, this is a fit case which requires a thorough inquiry, number one. Number two, till the inquiries or the report of the inquiry is placed before this honorable court, there is a need in the interest of justice to stay on for the proceedings in pursuant to the order pass.
All further proceedings already that has been put into.
Now the
entries are changed.
Well, documents have not been changed since we have filed objections, but they did not accept our objections. But they came to know that we have filed and we have already served them the copy that we are filing it. So now, having accepted that, they are awaiting the orders of this honorable court in order not to proceed. Otherwise, they are saddled with the cost also by the order of this court. Kindly see, there is an order of cost as well. So there is a threat of abuse of the process of court at the hands of the respondent number 3 to 5.
What is the apprehension now you have?
So, my lord, I have already explained in my prayer for interim relief that there is a threat of
What is your good name?
myself, my lord, Sanket.
Heard learned counsel Sri Sanket Yanagi for the review petitioner. Should notice to the respondents, learned HCGP or AGA?
Jailing. AGA, my lord.
AGA is directed to take notice for respondents 1 to 3. You will take?
Only one man. Government.
Notary. Petition copy ಕೊಟ್ಟಿದ್ದೀರಾ ನಿಮಗೆ ಇಲ್ವಾ?
ಕೊಟ್ಟಿದೆ ಸರ್.
ಮತ್ತೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್
ಅಲ್ಲ, ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಅಂಡ್ ತಹಶೀಲ್ದಾರ್ ಮೇಲೆ.
Three there are, 1, 2 and 3.
ತಹಸೀಲ್ದಾರ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ನೀವು ಅಪೇರ್ ಆಗಲ್ಲ
appear
ಮತ್ತೆ
one to
1 to 3.
1 to 3.
1 to 3.
KGAs. I have to take this for respondents 1 to 3, emergent notice to respondents 4 to 6. Learned counsel for the petitioner is permitted to take out hand summons and other modes of service to respondents 4 to 6. Copy ಬಂದಿದ್ಯಾ? Copy.
What is copy?
In the meanwhile, the proceedings before the revenue authorities in pursuance to the order passed by this court shall be maintained as it is. There shall be a status quo order. Whether they have got into the property by virtue of this order?
Not yet, my lord. They tried, but they haven't.
Who's in possession?
We are in possession of the property.
But I'll grant you status quo.
No, my lord, that is pertaining to that. Otherwise, if they create multiple documents or try to alienate the property,
No,
they
the entry-
create third-party interest based on the documents having been executed in their favor.
Have you filed any such application here?
Yes, my lord. I number 4
What is that?
for
It is
stay
only
of
stay.
operation and execution.
Sir,
Delay is there, my lord.
how I can stay my own order? You have to file an application not to alienate.
My lord, you lordships are aware of the legal position when the court is of the opinion that the court has been misled or misdirected, fraudulently driven to pass some order which do not have, in my respectful submission, the sanctity to have it be enforced in accordance with law. So, my respectful submission is that under those circumstances, this Honorable Supreme Court has in Ketinov judgments has said the court is not powerless when it is been brought to the notice of this Honorable Court that this court was misdirected or misled and fraud was played on the court to recall its order or to stay its own order. But this is a classic case where the court has been misled by the petitioners by production of certain fraudulent documents.
Now entries are changed in the name of the respondents 4 to 6.
I'm instructed that they have not been changed and they are going to be changed at the final stage now.
There is a delay is there, my lord. Delay 574 delay is there, my lord.
I was not a
I'll
party.
file an objection, my lord.
You want to file objections?
My lord, I am sorry. It appears that the state appears to be handing low with the petitioners before this court
Mark
earlier.
it. Till the next date of hearing, the parties shall maintain status quo with regard to the property in question, including non-alienation of the property till further orders are passed. The respondents are at liberty to file objections to the applications filed by the petitioner. All this matter after service of notice.
Great.
Yes, sir.
Appearing for the petitioner, Your Honor.
I seek for a 3 days time. I will place my objections. I'm also on my, but I'm not feeling well also. So I'll place my objections. Kindly accommodate me 3 days of time, my lord.
This application is filed seeking interim relief until the main petition is decided. My lord, the backstory, if this court were to permit me.
What is the order you are challenging?
The order is at page 12, my lord.
What is that order?
Interim application on IA number 1 and 2, wherein visitation was granted to me on the first and third Saturday between 2:30 to 5:30 within the mediation premises, court hall premises, as well as on every Saturday between 6 to 7, an audio call for 15 to 20 minutes. So this order has been challenged by me.
This order is questioned by you, the father.
The father.
Visitation rights first and third Saturday every month.
First and third Saturday between 2:30 to 5 o'clock every month. prior to this petition being filed, for almost 6 years, I have lived under the same roof with my son. The backstory is that I got married in the year 2014. My child was born.
The order is complied.
Yes, my lord.
You're meeting the child.
Yes, I'm meeting the child in the mediation center.
Ah.
The application was filed because my father has fallen very sick. He's a heart patient. And so if the visitation can be extended and I can take my child out
Where?
anywhere, my lord, between 9 to 5 on Saturdays,
Hmm.
either take my child to my home, spend some time so that even my parents get access.
So this is restricted to the visitation room of the family court.
Yes, my lord.
How old is the child?
Now the child is going to be 8 years old on 25th of February this year.
My lord, all the medical records which are produced are all concocted. I inquired with the doctor. The medical records of his father, husband's father, they are relying upon. My lord, secondly, if page number 16 may be looked into, my lord. Kindly, my lord, writ petition page number 16.
Yes. Hmm.
In that, my lord should see there are various FIRs has been filed against the husband. He carries an aggressive behavior against the child as well as the wife. My lord, apart from this, the child is suffering with the ADHD. He frequently needs some medical attention. And these kind of aggressive behavior cannot be confronted in front of a child, my lord. I will produce all these documents along with the video where he shows an aggression against the child. My lord, for that, I am seeking 3 to 4 days of time. Let me place those on records, my lord.
All right. This visitation rights you are continuing?
Yes, my lord. We are continuing. We are complying with that.
All right. When you will file?
I will file it in 3 or 4 days, my lord.
Friday, my lord.
All right. We list it on Friday?
Hmm.
You want on Friday?
Friday.
Much obliged. I will place it before that.
What does your client do?
He's a software engineer, my lord.
What about your client?
Lord, she is also working in a company. Both are employed.
Different companies.
Yes, my lord, different company.
Learned counsel for the petitioner and respondent are present. Counsel for respondent seeks time to file objections to IA number 1 of 25. Same is granted. Call this matter on 7th.
Obliged.
How old is the child?
8 years.
8 years.
All right. Now he is going to what's class?
Second standard, my lord.
So the school functions from what time to what time?
Lord, I will just inquire it and I will
Find
report
out from your client.
Nine to 3, my lord.
9 to 3.
3.
All right. You keep the child present at 4.
My lord.
Keep the child present at 4 on the next date, 7th.
Please, my lord, I will do that.
You file your statement.
Please.
They'll let them also file. You keep the child present at 4 o'clock.
Please.
All right.
Please, my lord, I will do it.
Much obliged.
Hmm. Detail number 2.
I appear for the respondent, my lords.
2.
Serial number 2.
I appear for the petitioner in this matter, my lord.
The respondent to
lords.
keep the child present at 4 p.m. before this court. Serial number in my class. Judgment ತಗೊಂಡಿಲ್ವಾ ಇದು? You're not urgent. Okay. Yes, you are appearing for
the appellant.
petitioner.
In serial number 1, my lord. List number 3.
One is urgent. Not informed you. Yes, who appears for the petitioner in second matter?
List number 3, serial number 2, I appear for the petitioner, my lord.
Yes,
I appear for the respondent, my lords.
yes.
My lord, if you This matter, my lord, is a civil petition presented under the Admiralty Jurisdiction and Settlement of Maritime Claims Act, wherein I had sought an interim relief of arrest of the defendant vessel. And the defendant vessel was arrested by this honorable court. Security was deposited in this court, and the defendant vessel has been released, my lord. Thereafter, my lord, the
The petitioner has to lead its evidence.
So
yes, ma'am.
vessel is now within the jurisdiction of this court?
No, my lord, she has sailed away, but the money that has been deposited as security is before this honorable court, my lord. Around 4.5 crores is deposited in this honorable court.
All right.
My lords, it's at the stage of evidence. The petitioner has to lead the evidence, my lords. Kindly a short date may be given, we could take it up, my lords.
So he has to lead evidence.
Yes, ma'am.
You have deposited security.
Yes, ma'am.
The vessel is out.
I beg your pardon.
Vessel is shored off.
Yes, my lords.
Vessel is not here anymore.
No, sir.
All
No,
right.
lords.
You lead evidence, what else you want?
Very well, my lord. I only request a slightly long date, my lord, because the petitioner is a foreign company, so the witnesses will have to come from abroad. In that sense, my lord, on 30th October 2024, my lord, Justice Sanjay Gowda had framed the issues. In those issues, my lord, issue number 5, whether the respondent vessel is able to establish that it is the commercial court alone established under the Commercial Courts Act would be entitled to entertain the claim, has already been decided on 17/1/2025, my lord, in a separate application that was filed by the respondent. So only issue numbers 1 to 4 remain to be decided by this honorable court, my lord. And my evidence is in respect of issue number 4 itself. The first 3 issues, the burden of proof is on the respondent, so they will also have to lead their evidence, my lord.
All right. Then at counsel for the petitioner and counsel for respondent are present. Counsel for the petitioner seeks time to lead his evidence. At his request, this matter after 4 weeks.
Yes, my lord.
Grateful, lords.
Grateful, my lord.
For the petitioner in this case, is the wife petition, my lord, seeking transfer from Chikmagalur Family Court
In serial number, madam.
5.
3 adjourn again. 4 adjourn.
I am for the respondent.
You're for?
Petitioner, my lord, wife's petition, my lord.
Transfer.
Yes, my lord.
Fill in the-
Petition. From Chikmagalur to
Any
Chennagiri.
objection?
The petitioner is the age 28 years, my lord. Traveling within 100 kilometers.
More than 100 kilometers, my lord.
Within
But
100.
From where to where?
From Chikmagalur to Chennagiri.
Chikmagalur to Chennagiri, my lord.
That is Davangere district, my lord.
No, petitioner is young, my lord,
Chennagiri
28 years. ಬಂದು ಹೋಗ್ಬೋದು.
Huh?
Petitioner ಬಂದು ಹೋಗ್ಬೋದು ಏನು ತೊಂದರೆ ಆಗಲ್ಲ. Already filed wakalat and conciliation ಗೆ
No, my lord.
the respondent
The
filed
wakalat has been filed
restitution
and
of conjugal rights,
certified
my lord.
copy.
The
And thereafter file this. Kindly permit to submit, my lord. That is on 15/7/2024. The petitioner has filed a criminal miscellaneous, my lord. Thereafter receiving the death to notice, they have filed the restitution of conjugal rights on 25/7/2024. Thereafter, that petition has been has to be transferred to Chennagiri, my lord. This is the petition, my lord, transfer petition.
So after you filed 125 proceeding, he has filed restitution.
Yes, my lord.
restitution of conjugal rights. Then the petitioner is appeared
Then
before this honorable court and filed wakalat.
After getting the certified copy, I have filed.
You filed restitution where?
In Chikmagalur, they have filed.
You filed
Chennagiri,
120.
my lord.
Huh?
Chennagiri.
Chennagiri.
She is residing in.
So the first petition is filed by you at
Yes, my
Chennagiri.
lord.
So you have to anyway go and attend there.
ಆದರೆ already
It is too near to him, my lord. He is
the-
working in
the
Kalasa.
petitioner filed wakalat before the family court, my lord, and case is posted for conciliation and mediation, my lord. Meanwhile, the petitioner is filed a CP, my lord.
That is the stage,
I
my
am
lord.
ready to take back the petition. Matrimonial home. Order sheet, my lord. 14/8/2024. The respondent is
One
present.
forty-seven of 24 is filed at Family Court, Chikmagaluru
Yes.
by the respondent.
Please.
And this 125 proceedings was filed when? Date ಬರೆಯಕ್ ಬರಲ್ವೇನ್ರಿ ನಿಮ್ಗೆ ನಿಮ್ petition ಅಲ್ಲಿ? 843 of 24 is filed when?
On 15/7/2024, my lord. That is in.
Synopsis ಅಲ್ಲಿ ಇದು ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆಯಕ್ ಬರಲ್ಲ. My petition, first petition filed under 125, date so and so. He filed next petition, date so and so.
In synopsis is mentioned, my lord. In the synopsis, my lord, serial number 3, that is 13/7 criminal miscellaneous filed by the.
ಬರ್ಕೊಳ್ಳಿ. I'll allow the petition. This petition is filed by the petitioner wife against the respondent husband, seeking transfer of the petition in MC 147 of 2024 pending on the file of Principal Judge Family Court at Chikmagaluru to the Senior Civil Judge at Channagiri. Full stop. It is contention of learned counsel for the petitioner that the petitioner and respondent got married on 21/4/24. Thereafter, petitioner returned to her maternal home on 27/5/24. Subsequently, petitioner filed a petition in criminal miscellaneous 843 of 24 for the Principal Civil Judge and JMFC Channagiri for maintenance, correct?
Yes, ma'am.
Subsequent to the receipt of notice ತಗೊಂಡಾದ್ಮೇಲೆ ಮಾಡಿದ್ರ?
Yes, ma'am.
Receipt of notice by the respondent in the said petition. The respondent husband filed a petition for restitution of conjugal rights before the Family Court at Chikmagaluru on 25/7/24. It is contended by the learned counsel that the petitioner does not have any income to maintain herself and she has no source of livelihood. She is staying with her parents.
She is residing separately, ma'am.
Residing separately.
Yes, ma'am, in Channagiri.
Residing separately at Channagiri. And whereas the respondent is residing at Chikmagaluru.
In Kadasa, he is working as a surveyor.
Chikmagaluru district. In Chikmagaluru district.
Chikmagaluru district.
And it would be difficult for the petitioner to travel to Chikmagaluru to attend the court proceedings, as she would have to travel alone and incur expenditure. Whereas the respondent is traveling and attending to the proceedings initiated by the petitioner wife at Channagiri. Under the circumstances, she seeks transfer of this petition filed by the respondent husband to Channagiri. Full stop. Per contra, learned counsel for the respondent objects to the arguments put forth by learned counsel for the petitioner on the ground that the distance between the two places is hardly 200 kilometers.
Within 100 kilometers.
100 kilometers.
100.
It would not be difficult for the petitioner to travel to Chikmagaluru to attend the proceedings. Full stop. Therefore, he seeks dismissal of the petition. I have heard learned counsel for both parties. Full stop. The petition initiated by the petitioner wife is the prior petition than the one initiated by the respondent husband, which is instituted after receipt of notice in the proceedings under section 125 of CRPC. Either way, respondent would have to travel to Channagiri to attend to the petition, criminal petition 843 of 24. Therefore, it would be in the interest of both parties that the matter from Chikmagaluru is transferred to Channagiri so that the matter could be agitated before one particular place, avoiding the travel and financial expenditure of the petition. Accordingly, I pass the following order. Petition is allowed. The matrimonial proceedings in MC 147 of 24, pending on the file of Principal Judge Family Court at Chikmagaluru, is ordered to be transferred to. You have any family court or in Channagiri?
No,
or
my
is
lord.
it
Senior civil judge.
Senior civil judge.
Yes, my lord.
So this court has the jurisdiction
Yes,
to
my lord.
deal with it.
Senior civil judge at the point.
It's ordered to be transferred to the senior civil judge at Channagiri, which shall try this matter along with criminal miscellaneous 843 of 24, along with clubbing the matter. Shall be tried on club.
No.
Please,
This is, same is junior civil judge.
Yes, ma'am.
Same is the
Civil
civil
judge.
judge.
Only
MC is
division.
the senior. Senior civil.
Principal
ಅದನ್ನೇ
civil
ಕೇಳಿದ್ದು.
judge.
Separate.
Separate. Courts are
Both.
Shall be
The same.
transferred to senior civil judge at Channagiri. Full
Channagiri.
stop. Astay sir. No need of clubbing and
Please.
trying to.
Please, ma'am. Much obliged.
The thief.
For respondent to this.
Hmm? ಹೇಳ್ರಿ ನೀವು ನಾವು ನೋಡ್ತಾನೆ ಇದ್ರಿ ಏನಾಗುತ್ತೆ? But argue the matter.
Lordship, the petitioner is seeking transfer from Chamarajnagar Court to Mysore Family Court, my lordship. The petitioner is having two minor children, my lordship. One is the age about 9 years and another is age about 4 years, my lordship.
From Chamarajnagara to Mysore.
Mysore Family Court, my lordship.
Yes.
The respondent is working in T. Narsi First Grade College, my lordship, and he has a handful of salary, my lordship. And while coming to petitioner, my lordship, is mercy on her parents, my lordship. She doesn't work anywhere, my lordship. Traveling from Mysore to Chamarajnagara without anyone's suggestion, it will be very difficult for her, my lordship.
For petitioner.
For the petitioner, my lordship.
So what is the petition that is pending? Yen petition pending is it?
Like criminal maintenance petition, my lordship.
No, this is filed by the respondent is the husband. He has filed restitution.
Restitution of money.
What have you filed? Have you filed any petition?
Yes, my lordship. Criminal number 736 of 24 for maintenance, my lordship.
That is pending in Mysore.
Mysore, my lordship.
736.
736 of 24, my lordship.
ಮಾಡ್ಬೋದು. ಆವಾಗಲೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ರಿ ಇಷ್ಟೆಲ್ಲ ಕೇಳ್ತಾನೆ ಇಲ್ಲ.
Last week submission.
ಬರ್ಕೊಡಿ.
My objection be recorded. My objection be recorded.
Objection. Petition is filed by the petitioner wife seeking transfer of matrimonial proceedings MC number 55 of 24 on the file of Senior Civil Judge CJM Chamarajnagara to the Family Court at Mysuru. It is contended by learned counsel for the petitioner that she got married to the respondent on 30th October 2014. And pursuant thereto, a male child is born from the marriage. But due to the quarrel and harassment, Male child is born and two children are there.
Two children, sir.
Male child is born and after that another second child was born. Pursuant thereafter, due to the discord and misunderstanding in the matrimonial life, the respondent started living separately by taking a separate house at the instigation of his brother and sisters. Full stop. Thereafter, the petitioner received summons from the court in MC number 55 of 24, whereby the respondent filed a petition for restitution of conjugal rights before the senior civil judge CJM Chamraj Nagara, which is pending adjudication. Full stop. Para. The petitioner also filed a petition for maintenance under Section 144 of BNS in Criminal Miscellaneous number 736 of 2024 for the family court at Mysore. What is the distance between Chamarajanagar and Mysore?
Almost 90 kilometers, my lordship.
On it. Petitioner has filed this petition on the ground that she is having two minor children and it would become cumbersome and tedious and expensive for her to travel to Chamarajanagar without the assistance of another attendant or a co-passenger. And moreover, traveling to Chamarajanagar along with two minor children would be very difficult. It is also contended that since the maintenance petition is pending in the family court at Mysore, the respondent husband would have to attend the same, and hence the present petition is filed seeking transfer of the proceedings before the Chamarajanagar court initiated by the respondent husband to the family court at Mysuru, so that the matter could be attended by the petitioner at the family court Mysuru, which would be close to her residence, thereby not incurring any financial expenditure and travel. Full stop. Para. Learned counsel for the respondent objects to the arguments put forth by the counsel for petitioner and contends that the initial petition came to be filed by the respondent for restitution of conjugal rights. Instead of joining the husband and living in the matrimonial home, petitioner has preferred to file a petition for maintenance. He also contends that the distance is not too far for the petitioner to travel to Chamarajanagar to attend to the family court proceedings. On these grounds, he seeks dismissal of this petition. I've heard learned counsel for the petitioner and respondent. The fact remains that the petitioner is residing at Mysore and the respondent is residing at Chamarajanagar. Two petitions are filed at two different locations. The petitioner is taking care of two minor children in their care and custody, living in Mysuru, has already initiated a petition for maintenance under the provisions of the BNS 144. in criminal miscellaneous 736 of 24. Have you taken notice in that?
Yes, yes, I have appeared.
The respondent has
I filed objection of-
accepted notice and is appearing in the proceedings. Under the circumstances, it would be in the interest of both parties and which would benefit the petitioner to avoid
Petitionaries are not a
travel
by case.
and expenditure to transfer the matter from Chamarajanagar to Mysuru. Accordingly, I pass the following order. Petition is allowed the proceedings in MC number 55 of 24 on the file of Senior Civil Judge CJM Chamarajanagar is ordered to be transferred to the family court at Mysuru. Ordered according.
Petitioner in this case. This petition filed by the wife seeking to transfer the divorce petition filed by the respondent husband from Bangalore to Hassan. In the year 2014 itself, the petitioner wife filed a petition in the Hassan and criminal miss 3/2014. The man seeking a maintenance and protection order under DV Act. It was allowed. And till today, the respondent husband not been.
Any objection?
Yes, my lord, I have objections. My lord. Actually, the marriage happened in the year
Let
2008.
him argue.
So the petition is a wife seeking to transfer the divorce petition filed by the respondent husband for the family court Bangalore to the Asana. Since 2014, the petitioner along with her minor daughter residing with under shelter of their parents. In the year 2014, she has filed a criminal miss 3/2014 seeking a maintenance and a protection order under DVR. That petition was allowed by awarding the maintenance in total 20,000 for the petitioner and a minor daughter. Till today, they have not been complied by the respondent as a respondent. Because of that, they have filed a recovery proceedings. The 3 consequent recovery proceedings are still pending and warrant is also issued. But the respondent police is systematically and intentionally avoiding to comply and provide the maintenance. In 2024 only, all of a sudden, he has filed a divorce petition before the family court. And after receiving the notice, he attended the mediation center also. But matter has not been settled. So the 200 kilometer away from Bangalore, and moreover, she is without any financial assistance. She is residing with minor daughter by taking care of education and other attending things. So it is very difficult to attending the court proceedings in the family court of Bangalore. It's very much required to transfer the petition before.
Yes.
Yes, ma'am. My lord, they got married in the year 2008, and after that.
Not required, sir.
Okay, yes, my
Why
lord.
you are opposing
Okay.
transfer? Only
Yes, my lord.
restrict your argument.
Yeah,
to
my
that.
lord. Yes, I will stick to the brief facts of the case, my lord. First, the respondent approached the District Legal Services Authority, my lord, on 18/3/2014. After that, after receiving the notice from DLSA, they have filed the DV Act, my lord. And moreover, from April 2012 itself, the petitioner is living away from the husband, my lord, from the respondent. After that, after several approaches, she never returned to matrimonial, my lord. And after 2 years, she files a DV Act, my lord. After 2 years of separation, she files the DV Act, and moreover, he is an unemployed, my lord. Respondent is an unemployed, and he met with an accident, and his hand is broken, my lord. He is not able to work as earlier. We used to work as a carpenter, small carpenter. Now he is unable to work anything. And my lord, there is a continuous harassment from the petitioner side, my lord. Kindly peruse annexure R1 of my objections, my lord.
ಏನದು?
ಅದರಲ್ಲಿ ಈ ಲಾಸ್ಟ್ ಮೀಡಿಯೇಷನ್ ಇದರಲ್ಲಿ ರೆಫರ್ ಆಗಿತ್ತು ಮೇಲೆ MC ಕೇಸಲ್ಲಿ, ಡಿವೋರ್ಸ್ ಕೇಸಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಆಗಿತ್ತು. ಮೀಡಿಯೇಷನ್ಗೆ ಇಬ್ರು ಕೂಡ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ರು. ಮೀಡಿಯೇಷನ್ 24/8/2024 ಮೀಡಿಯೇಷನ್ ಪ್ರೋಸೆಸ್ಸಲ್ಲಿ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ರು. ಅವತ್ತಿನ ದಿನ ಮೀಡಿಯೇಷನ್ ಪ್ರೋಸೆಸ್ಸಲ್ಲಿ ಇವನ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಡ್ವೊಕೇಟ್, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ನಾನೇ ಮೇಲೆ. ಅಲ್ಲೇನಾಯಿತು, ಮೀಡಿಯೇಷನ್ ಪ್ರೋಸೆಸ್ಸಲ್ಲಿ ಕೂಡ ಪಿಟಿಷನರ್ ಫಾದರು ಬ್ರದರು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಅಸಲ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡಿದ್ರು. ಫಿಲ್ತಿ ಲ್ಯಾಂಗ್ವೇಜಲ್ಲೆಲ್ಲ ಅಬ್ಯೂಸ್ ಮಾಡಿದ್ರು. ಕೋರ್ಟಿಂದ ಆಚೆ ಬರ್ತಿದ್ದಾಗೆ ನಾನು ಮತ್ತೆ ಅವರು ಫಾದರ್ ಎಲ್ಲ ಆಚೆ ಹೋಗ್ತಿದ್ದಾಗೆ ಒಂದು ಪ್ರೈವೇಟ್ ವೆಹಿಕಲಲ್ಲಿ, ಅವ್ರದ್ದೇ ವೆಹಿಕಲಲ್ಲಿ ಕಿಡ್ನಾಪ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್. ಇವನ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ಕಂಪ್ಲೇಂಟ್ ಮೇಡಮ್ ಬಿಫೋರ್ ದ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಂಡ್ ಬಿಫೋರ್ ದ ಕಮಿಷನರ್ ಮೇಡಮ್. ಅಂಡ್ while taking him to Hassan, they have assaulted him and they have not provided even a drop of water to him. And they, after filing of the complaint before the Wilson Garden police station, they left him to go back to Bangalore at midnight, my lord, 1 AM. He reached Bangalore around at 5:30 AM, my lord. And his face was having very swelling, sir. ತುಂಬಾ ಊದ್ಕೊಂಡಿತ್ತು ಮುಖ ಎಲ್ಲ, ದವಡೆಗೆಲ್ಲ ಹೊಡೆದಿದ್ದು. ಅದಾದ್ಮೇಲೆ ಇದೇ ರೀತಿ ಇವನ್ ನಾನು ಕೂಡ ಹಾಸನ್ ಕೋರ್ಟಲ್ಲಿ ತುಂಬಾ ಸರಿ ಅಟೆಂಡ್ ಮಾಡಿದ್ದೀನಿ ಮಲಾಡ್ ಇದೇ ಕೇಸಲ್ಲಿ. ಅಲ್ಲೂ ಕೂಡ ಆನ್ ರೆಕಾರ್ಡ್ ಹೋಗಿದ್ದೀನಿ. ಅಲ್ಲೂ ಕೂಡ ಕೋರ್ಟ್ ಪ್ರಿಮಿಸಸ್ ಅಲ್ಲಿ ಜಡ್ಜ್ ಮುಂದೆ ಕೂಡ ತುಂಬಾ ಕೆಟ್ಟದಾಗ ಬೈಯೋದು, ಅಲ್ಲಿ ಕೋರ್ಟಿಂದ ಆಚೆ ಬರ್ತಿದ್ದಂಗೆ ಹೊಡಿಲಿಕ್ಕೆ ಮಾಡೋದು, ಆ ಥರದ್ದು ಮಾಡ್ತಾರೆ ಪಿಟಿಷನರ್ ಮತ್ತೆ ಅವ್ರ ಪೇರೆಂಟ್ಸ್ದು. ಮತ್ತೆ ಅವತ್ತಿನ ದಿನಾನು ಅಷ್ಟೇ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮುಂದೆನೆ ಗೇಟಿಂದ ಆಚೆ ಬರ್ತಿದ್ದಾಗೇನೆ ಈ ರೀತಿ ಮಾಡಿದ್ರು ಮೇಡಮ್. ಇದಕ್ಕೆ ಈಗ ಇನ್ನೊಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕೂಡ ಫೈಲ್ ಆಗ್ತಿದೆ ಮೇಡಮ್, PCR. ಅವ್ರ ತಂದೆ ಕೂಡ ಏಜ್ಡ್ ಪರ್ಸನ್, ಹಾರ್ಟ್ ಪೇಷಂಟ್ ಮೇಡಮ್. ಅವ್ರನ್ನು ಕೂಡ ನೆಲಕ್ಕೆ ತಳ್ಳಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಆಗಿದೆ ಅನ್ನೋದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ಹೋಗಿ ಕಾಲ್ ಹೋದ್ಮೇಲೆ ಅವ್ರನ್ನ ಬಿಟ್ಟು ಕಳ್ಸಿರೋದು ಮಧ್ಯರಾತ್ರಿ. ಮತ್ತೆ ಈಗ ಇವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಂದು ಡಯಾಬಿಟಿಕ್ ಅನ್ಎಂಪ್ಲಾಯ್ಡ್, ಮತ್ತೆ ಅವ್ರ ಫಾದರ್ ಕೂಡ ಹಾರ್ಟ್ ಪೇಷಂಟ್ ಮೇಲೆ. ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಿಟ್ರೆ ಬೇರೆ ಯಾರು ಇಲ್ಲ ನೋಡ್ಕೊಳ್ಳಿಕ್ಕೆ. ಅವರು ಕೂಡ ಅವ್ರನ್ನ ನೋಡ್ಕೊಳ್ಬೇಕು. ಪ್ಲಸ್ ಅಕ್ಯೂಟ್ ಡಯಾಬಿಟಿಸ್ ಇರೋದ್ರಿಂದ ಅವರು ಟ್ರಾವೆಲ್ ಮಾಡೋದಕ್ಕೆ ತುಂಬಾ ಕಷ್ಟ ಆಗುತ್ತೆ ಮೇಡಮ್. ಇಸ್ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಮೇಡಮ್. ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಸ್ ಎ ಡಯಾಬಿಟಿಕ್ ಮೇಡಮ್. Respondent husband is a diabetic. He is suffering from diabetes.
Diabetes is so big that you cannot travel.
ಅಲ್ಲ, ಐ ಡಯಾಬಿಟಿಸ್ ಇದೆ ಮೇಡಮ್. ಅಲ್ಲ, ಮೇನ್ ಆಗಿ ಇನ್ನೊಂದು ಏನು ಅಂದ್ರೆ, ಈಗ ಅಲ್ಲಿ ಹೋದ್ರೆ ಇವ್ರಿಗೆ ಅನ್ಸೇಫ್ ಅನ್ನೋ ರೀತಿಲಿ ಅವರು ಒಂದು ಅಟ್ಮಾಸ್ಫಿಯರ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ 10 years ಇಂದ ಇವ್ರು ಅಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದ್ರು, ಬರ್ತಾ ಇದ್ರು, ಅಲ್ಲಿ ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ರು ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ. ಈಗ ಅಲ್ಲಿ ಹೋದ್ರೇನೆ ಇಡೀ ಫ್ಯಾಮಿಲಿ ಬರ್ತಾರೆ, ಅವ್ರ ಜೊತೆಗೆ ಒಂದು ಇಬ್ರು ಬೇರೆ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ಕೋರ್ಟ್ ಪ್ರಿಮಿಸಸ್ ಅಲ್ಲಿ ಹೊಡಿಲಿಕ್ಕೆ ಬರ್ತಾರೆ, ಕೆಟ್ಟದಾಗ ಬೈತಾರೆ. ಇವನ್ ನಾನು ಕೂಡ ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ, ಈ ರೀತಿ ನಡ್ಕೊಬಿಡಿ, ನಿಮ್ದು ಏನಿದ್ರು ಜಡ್ಜ್ ಮುಂದೆ ಹೇಳಿ, ನಿಮ್ದು ಏನೇ ಇದ್ರು ಕೋರ್ಟ್ ಮುಖಾಂತರ ಇದ್ ಮಾಡಿ ಅಂತ. ಕೋರ್ಟ್ ಕಾರಿಡಾರ್ಸ್ ಅಲ್ಲಿ ಈ ರೀತಿ ನಡ್ಕೊಳ್ತಾರೆ.
Gunda activities you are doing.
No,
Yes,
my
ma'am.
lord. What allegations?
What is the background of this petition?
Petitioner
What is
is
the
a
background of the petitioner and her family?
petitioner's father is a wealthy person, my lord. Our brothers are also very wealthy. Our brothers were working in Dubai, my lord. They are wealthy, and she comes in the Ford Endeavor, my lord. Ford Endeavor worth 35 lakhs from Hassan to Bangalore. What all they are contending is completely false, my lord. They are she is running a beauty parlor in Hassan.
ಮಾಡಬಾರ್ದಾ? ಮಾಡಬಾರ್ದಾ?
ಅಲ್ಲ, ಮಾಡ್ಲಿ my lord, but they are claiming that she is unemployed. Falsely claiming that she is unemployed.
That is, the court will decide whether she is entitled for maintenance or not.
Yes, ma'am.
It is different.
But rest of the things I don't have objections. But the main thing is respondent ಅಲ್ಲಿ ಹೋಗ್ಲಿಕ್ಕೆ ಅನ್ಸೇಫ್ ಅನ್ನೋ ರೀತಿಲಿ ವಾತಾವರಣ ಆಗ್ಬಿಟ್ಟಿದೆ. ಇವನ್ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಜೊತೆಲೆ ಅವ್ರು ಆ ರೀತಿ ನಡ್ಕೊಳ್ತಾರೆ. ನಾವು ಜೊತೆಲಿ ಇದ್ರು ಕೂಡ ಜಡ್ಜ್ ಕೂಡ ಅವ್ರು ವಾರ್ನ್ ಮಾಡಿದ್ದಾರೆ, ಈ ರೀತಿ ನಡ್ಕೊಳ್ತಾರೆ ತುಂಬಾ ತಪ್ಪು ಅಂತ. ಅದನ್ನು ಕೂಡ ನಾವು ರೇಟಿಂಗ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ಗೆ ಸಬ್ಮಿಷನ್
Sir,
ಮಾಡಿದ್ದೇವೆ.
they petitioner and her family have any criminal background?
I don't know, my lord, but they behave in that manner in the court premises, my lord.
You go lodge a complaint.
We have lodged the complaint, my lord. We have provided.
That then the case will go, that will take care of him.
It is highly unsafe for the respondent to go to the Hassan court, my lord.
No.
That is the problem.
Already there is a
He
case.
was attending the court.
Sir, there is a case registered against you.
Yes,
Whether you like it or not,
Yes, ma'am.
you have to go there to attend that case.
We will attend the criminal case, whatever the recovery cases proceedings, we will attend there, my lord, in Hassan.
That time there is
But
no,
MC petition, we can't be transferred over there, my lord.
no, when you are going for this DV case,
Yes, ma'am.
that time there's no problem.
Even then, they were creating problems, my lord.
So when you are already attending that, you go and attend one more.
That is impossible. It is just, complaint is filed on August 2024, my lord. It is just recent incident. That's why after that only he
Filed.
can't,
That is filed by you. Divorce petition is filed by you in
filed by my lord.
24,
Yes, ma'am.
almost after 10 years.
In 2024, after 20 years.
Hmm?
But before that, I have filed the MC petition for restitution of conjugal rights. It was allowed in the 2015 itself, my lord.
Hmm.
After that, she never complied with the order of the family court, my lord. She never returned to family. That's one.
She
On
doesn't-
that basis and
Yeah, you don't want to go and live with him.
There is no possibility now because.
Then why you want to call him and harass him? Is it in your
No,
place?
no, my lord.
You want to show
There is-
your muscle power?
No, no, no.
Huh.
There is no any criminal attitude and criminal force.
Hmm.
Moreover, my learned friend filed this divorce petition. Subsequent to that, this complaint was lodged. Moreover, that still file is
You
objection.
want to live with him or not?
I don't know. I may be instruct to the party.
But
But-
you, when he filed restitution, first he filed restitution,
yes, ma'am.
you don't want to join.
No,
You are
there-
wealthy.
There is no restitution
It
proceedings
appears
here.
that you are wealthy,
No, no,
financially
my
very
lord. There is
sound.
no restitution petition is here.
Restitution
divorce
is allowed,
petition
my
was-
lord. Restitution is allowed.
Yeah.
In 2015 itself, restitution is allowed.
Party or part, she appeared?
No.
She was appeared, my lord.
Huh?
She appeared in that case.
Ah,
And yes, my lord.
Contested.
Contested, my lord. After receiving the notice, she appeared for 2-3 days.
Ah.
And after receiving multiple notices from the court, then she awarded to appear, my lord.
ಎಲ್ಲಿ file ಮಾಡಿದ್ರಿ?
Before the family court, my lord, Bangalore.
She came and appeared here.
Came and appeared here.
So she didn't want to join you.
No, my lord. She never joined.
Petition is allowed.
Petition was allowed.
ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
ಅದೇ ಸ್ಮಾಲ್ ಕಾರ್ಪೆಂಟರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದೆ. ಈಗ ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಕೇಸಲ್ಲಿ 1 year ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಹೋಗಿದ್ವಿ ಮೇಡಮ್. 3 months ಅಲ್ಲಿ. ಅದೇ ಮೇಂಟೆನೆನ್ಸ್ ಪಿಟಿಷನ್ ಇದು ಮೇಂಟೆನೆನ್ಸ್ ಪೇ ಮಾಡಕ್ ಆಗ್ದಲೇ ಇರೋದ್ರಿಂದ. ಕಾರ್ಪೆಂಟರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು ಮೇಡಮ್. ಬೈ ಹ್ಯಾಂಡ್ ಒಂದು ಬ್ರೋಕ್ ಆಗಿ ಆಪರೇಷನ್ ಆಗಿರೋದ್ರಿಂದ ವೆಯ್ಟ್ ಲಿಫ್ಟ್ ಯಾವುದು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅವ್ರಿಗೆ. ಅದರಿಂದ ಹೆವಿ ವರ್ಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಮ್ಯಾಕ್ಸಿಮಮ್ ಒಂದು 10,000 ಅರ್ನ್ ಮಾಡ್ತಿದ್ರು.
What she is doing?
She is running a beauty parlor in Hasan, madam.
Why didn't you settle the matter?
I will instruct the party, my lord.
We tried multiple
But
times, my lord.
What happened here, since 2014, admittedly, she is separately residing in Assam. He is attending all the proceedings at 2014. Just all of a sudden, he filed a divorce petition. That too, the recovery proceeding was initiated. The warrant was issued by in accordance with law only. To avoid that clutches, she making this effort. Anyhow, I am happy to reunion, but I instructed my party. But what allegation made against the harassment and other thing is totally false, my lord. Moreover, she has what in support of their allegation is not been filed any complaint in earlier to their divorce
It's
petition.
your grievance against her. Why you want divorce?
My lord, she never wanted to come back to the matrimonium. From the 2012 till today, she has not returned to matrimonium. We have made several approaches.
You are working only as a carpenter.
Yes, my lord.
She is having a parlor.
Parlor after separation, my lord.
ಆಯ್ತು, ಇವಾಗ ಕರ್ಕೊಳ್ರಿ ಜೊತೆಗಿರಿ.
But she never come to, she never.
He's coming ಅಂತ.
ಅಲ್ಲ,
ಅಲ್ಲೇನಾಗಿದೆ my lord,
keep the parties before the.
my lord, ಒಂದು 10 times mediation ನಡೆದಿದೆ my lord. Even ಹಾಸನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ honorable judge also tried multiple times my lord to convince the party. First they demanded 6 lakhs rupees, my lord. Then they raised it up to 8 lakhs. We agreed for the 8 lakh also, and the entire petition was also ready, and the joint memo was also ready, my lord. ಆ ಡೇಟ್ ಅಲ್ಲಿ ಇನ್ನೇನು ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗ್ಬೇಕು ಅನ್ನೋ ಟೈಮಲ್ಲಿ ಅಗೈನ್ ದೇ ಡಿಮ್ಯಾಂಡೆಡ್ 15 lakhs, my lord. ಏಕ್ದಮ್ 8 lakhs to 15 lakhs ರೈಸ್ ಮಾಡಿದ್ರು.
Already you find out from your client whether there is any possibility of settlement.
My lord, even
I will talk
petitioner's
with-
father is present before.
Huh?
Petitioner's father is also present before.
Who asked him to be here? That is the petitioner.
Petitioner is unable to.
He's from Bangalore.
Yes, my lord.
Why he has not come? Why you kept the father present?
He-
ಅವ್ರನ್ನೇನು ಕರ್ಕೊಂಬರ್ದ್ರಿ?
I just wanted to come.
Wanted to watch the court, your arguments.
Anyway.
ಕರೀರಿ ಅವರು. ಅನ್ರಿ ವಿಶ್ವರೂಪ ಅವರ ನಿಮ್ಮ ಹೆಸರು?
Yes, my lord.
ಸ್ವಲ್ಪ ಅಲ್ಲೇ ಇರು. ವಿಶ್ವರೂಪನ ನಿಮ್ಮ ಹೆಸರು?
ವಿಶ್ವರೂಪನ ನಿಮ್ಮ ಹೆಸರು?
ವಿಶ್ವರೂಪ. yes.
ಕನ್ನಡ ಬರುತ್ತಾ?
ಕನ್ನಡ ಬರುತ್ತಾ ಅಂತ
ಕನ್ನಡ ಬರುತ್ತೆ.
ಏನಾಗಿದೆ ನಿಮ್ಮ ಮಗನ್ಗೆ?
ಮುಂದೆ ಹೋಗಿ.
ಅಲ್ಲ
ಇಲ್ಲೇ ಬನ್ನಿ, ಈ ಕಡೆ ಬನ್ನಿ. ಇಲ್ಲಿ ನಿಂತ್ಕೊಳ್ಳಿ.
ಅಲ್ಲೇ ಅಲ್ಲೇ
ಕಡೆ
ಹೋಗಿ
ಬನ್ನಿ.
ಮಾತಾಡಿ.
ಅಲ್ಲೇ ಬನ್ರಿ ಮೈಕ್ ಹತ್ರ.
ಅಲ್ಲೇ ಇಲ್ಲೇ ಬನ್ನಿ ಬನ್ನಿ.
ಅಲ್ಲೇ ಹೋಗಿ.
ಇಲ್ಲೇ ಮೈಕ್ ಇದೆ ಬನ್ನಿ ಇಲ್ಲಿ.
ಕನ್ನಡ ಬರುತ್ತೆ ಸರ್.
ಏನಾಗಿದೆ? ಒಂದು
ಸರ್
ಏನಾಗಿದೆ ಅಂತ
ಹೊಂದಾಣೆ ಆಗಲ್ವಾ?
ಸರ್ 2008 ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಮದುವೆ ಆಯಿತು ಸರ್. ಒಂದು 6 ತಿಂಗಳು ಸ್ವಲ್ಪ ಸಮಾಧಾನವಾಗಿತ್ತು ಸಂಸಾರ. ಆಮೇಲೆ ಸ್ವಲ್ಪ ಸಣ್ಣ ಪುಟ್ಟ ಡಿಫ್ರೆನ್ಸ್ ಆಫ್ ಒಪಿನಿಯನ್ಸು, ಸ್ಕ್ವಾಬಲ್ಸು ಸ್ಟಾರ್ಟ್ ಆಯಿತು. ಮತ್ತು ಈ ಹುಡುಗಿಗೆ ಅಂದರೆ ನಮ್ಮ ಸೊಸೆಗೆ ಥೈರಾಯ್ಡ್ ಪ್ರಾಬ್ಲಮ್ಸು ಅಥವಾ ಬೇರೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು 2010ಇಂದ 11ವರೆಗೂ ಟೋಟಲ್ಲು ಟ್ರೀಟ್ಮೆಂಟ್ಸು ಆಯಿತು. ಅಲ್ಲೇ ನಮ್ಮ ಮನೆ ಹತ್ರ ಒಂದು 2 ಕಿಲೋಮೀಟರ್ಸ್ ಡಿಸ್ಟೆನ್ಸಲ್ಲಿ ವನಜಾಕ್ಷಿ ಅಂತ ಡಾಕ್ಟರ್ ಇದ್ರು ಅಲ್ಲಿ.
ಅಲ್ಲ ಬ್ರೀಫ್ ಆಗಿ ಹೇಳಿ. ಪ್ರಾಬ್ಲಮ್
ಸರ್ ಪ್ರಾಬ್ಲಮ್ ಅಂದರೆ
Ask him whether his son wants to join and live with the wife.
ನಿಮ್ ಮಗ ಅವ್ರ ಜೊತೆಲಿ ಹೋಗ್ಲಿ ಬಾಳ್ಲಿಕ್ಕೆ ತಯಾರಿದಾರ, ಅವ್ರು ಬಂದ್ರೆ ನೀವು ಒಪ್ಕೊಳಕ್ ರೆಡಿ ಇದೀರಾ ಅಂತ ಕೇಳ್ತಿದಾರೆ ಸರ್.
ಸೊಸೆ ಬಂದ್ರೆ ನಮ್ಗೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಸರ್.
All right, you keep
ಸರ್ ಬರ್ಲಿ, ಬಂದು ಚೆನ್ನಾಗಿರ್ಲಿ ಸರ್.
You keep your party, check, take instructions. If they're willing to join and what is her grievance, put forth that on the next date. All right? Stay is granted here?
Yes,
All right, call this matter after 2 weeks, give a date.
Interim order made.
Interim order extended.
Petitioner is seeking the transfer of MC 291 of 204 filed by respondent for the divorce from first additional senior civil judge Bangalore to first additional senior civil judge JMFC Court Chitradurga.
Heard learned counsel for the petitioner issue notice to respondent. Counsel for the petitioner is permitted to take out notice to the respondent by way of hand summons in the matter pending before the
First additional senior civil judge Bangalore
rural.
Yes, ma'am.
Matter pending before the family court at Bangalore.
Family court, first senior civil judge.
First senior civil judge.
First additional senior civil judge Bangalore
rural.
Yes. In MC 291 of 2024.
MC 291. There shall be stay of further proceedings. In MC 291 of 24 on the file of first additional senior civil judge Bangalore rural till next date of hearing.
The respondent numbers 1 and 2 have had application objecting in the execution petition. But that application, my lord, the objections was filed and trial court pleased to hear the application and rejected the application. Against which, my lord, the appeal was filed. Initially, appeal was dismissed and subsequently correction order was made by allowing the appeal.
Stay is here, stay is granted.
No, ma'am.
Where is the respondent?
But sir,
What are you seeking now?
now, my lord, the setting aside the order passed by the appellate court.
What order are you challenging?
Kindly come to the page number 17. Then order passed by the appellate court. Page number 29 is the operation portion of the order. The appeal filed by under order 41 rule 1 read with 104 of Code of Civil Procedure is hereby dismissed. Correction ಮಾಡಿದ್ದಾರೆ subsequently. by order dated 19/4/2021 stands corrected as allowed. The impugned judgment and decree in execution petition 250 of 2013 dated 19/11/2018 on the file of second additional civil judge and JMFC Mandya is hereby confirmed. While order dated 19/4/2021 stands cancelled, set aside, and the matter is remitted back to the trial court. Now, my lord, the order of the execution court, Lordship may kindly come to page number 44.
So the matter before the RA court is set aside, is it?
Yes, my lord, the order passed in the execution court, my lord, kindly come to page number 44. The order dated 19/11/2018 has been set aside and remitted back to the execution court to consider the application offense.
Which application?
But order for one rule 99 application has been filed. My lord, there are two distincts, my lord, order 21 rule application. My lord, the obstructor in execution proceedings, he will file application objecting the execution proceedings. But order 21 rule 99 application, my lord, when a party has been dispossessed during the execution proceedings.
Who are you?
My lord, I am the decree holder.
Hmm.
I did not dispose, I am not at all dispossessed. We have not at all interfered with his possession. Though, my lord, in order to obstruct the, delay the execution proceedings, my lord, the present application was filed.
By third party?
Third party. The page number 44 is the order of the trial court. It was well appreciated order has been passed by the execution court.
Page number?
44. But the starts from page number 44. But the reasons, my lord, the kindly come to page number 50, my lord. 50, para 13. Para 13, on careful scrutinizing all the boundaries mentioned in the decree and present sale deed date on dated 23/12/2017 and sale deeds of objector number 1 and 2 on dated 14/6/2006 and 18/2/2008 are concerned. It clearly goes to show that the total extent of land bearing suit number 84, survey number 84/Paiki P1 is having 1 acre 9 guntas. Out of that, 17 guntas land has been purchased by the objector number 1 from the brother of JDR number 1, namely Suresh. The objector number 2 had purchased 16 guntas of land from the brother of JDR number 1, namely Mariswamy, and 16 guntas land purchased by the DHR from the JDR number 1. So the lands are entirely different lands, different boundaries. Considering the same, that the trial court please to reject the application, it may not be necessary. My lord, the appellate court, my lord, they interfered with the order of the trial court and reversed the findings. Initially,
So
my
the
lord,
objector application was rejected in the executing court.
please,
So that is challenged in RA.
RA.
And what happened? That is allowed
Please, my lord, RA reversed, RA allowed.
and directed the matter to be tried again. What is wrong in the order?
Now, my lord, the properties are the different properties.
That is matter, you have to read evidence there.
Now, my lord, order 90s, my lord, this is
Sir,
not-
whether it is 2197 or 2199 or 100, 101, 2.
Please,
What is the procedure to be adopted by the executing court?
my lord, it has to be tried as a suit.
That's all.
That's true, my lord. That's
So
true. It
go
has
and agitate all your remedies there. Let's take, where is the other side? He's not here. No stay can be granted. Now, what is happening in the executing court?
No, my lord, it's still pending. Sale deed already executed, mutation.
Correct, sir, you may succeed.
Please.
What happens is whether the properties are different,
Please.
whether he has any right. Now, entire rights has to be decided by that particular court because he has no other remedy.
Please, my lord, I concede, my lord, my respectful submission, my lord. Order 21, rule 97, my lord, then it has to be tried. Rule 99, my lord, when it comes, when the party is
Possession.
dispossessed.
Correct.
Here, there is no question of dispossession.
But you have to argue there.
We have argued before the trial court considered that. Appellate court reversed that.
My lord, the 20 may permit me to.
So that has to be heard now, no?
Please, my lord. That has to be heard.
I'll hear you.
Please,
I'm not disposing it now.
please,
Other side is not here.
please,
If that issue is adjudged by the court,
please,
the executing court,
please,
which has been omitted or not considered by the
please,
appellate court,
please.
this court will consider it.
Definitely, please.
Counsel for appellant is present, no representation on behalf of respondent. Call this matter on. What is the property?
But agricultural land.
Agricultural lands.
Specific performance would got decreed and the sale
Which?
deed got executed. DHR not tell.
17th?
Please.
The plaintiff suit is decreed for specific performance. The appeal, in the appeal, appellate court remanded the matter for fresh consideration. That needs to be stayed.
Who are you, plaintiff?
I am the plaintiff,
So your suit came to be?
decreed.
Then what happened?
The respondent preferred an appeal. In the appeal, the appellate court remanded the matter for proceeding.
Heard Learned Counsel issue notice to respondent. I shall be stay of operation execution of the impugned judgment and decree dated 29/10/24 passed by Principal Civil Judge, Senior Civil Judge and CJM Davankare in RA number 49 of 22 till next date of hearing. Issue notice aitalla. Give a date. Followed. Kardude. 13, 11, 13, 16 and 17.
60. Nothing to respondents.
All these matters, I think the regular court will be resuming from Monday. So next week, you can take
Kindly on 11th, my lordship, serial number 11th.
11, serial number 11, 11th.
My lord, I have a difficulty in 17, matter number 17. My lord, this is probate matter and it was originally posted for 7th of February for evidence. My lord, I filed the affidavit already 5 days back and the petitioner is managed to travel from his professional work assignment from Guwahati to Bangalore today. My lord, they posted for leading the evidence on 7th.
Yes.
That is the only thing.
7th.
7th. Original date was 7th. It may be posted for leading the evidence on 7th.
Is that?
Before the
regular court will be sitting from next week.
It will be posted before the central project coordinator.
For evidence.
Yes, for evidence.
Okay. On 7th.
On 7th.
Very good. The serial number 17, right?
17.
Serial number 17 matter is posted, shall be posted on 17th for recording of evidence before CPC.
CPC on 7th.
On 7th. Party shall keep himself himself present before the CPC.
Yes, ma'am.
At what time? 11 o'clock?
11 o'clock is okay.
AM, 11 AM.
11 AM.
For recording of evidence.
Yes.
Yes. CPC. Project coordinator. 13. 16, 16.
16 any date next week.
16 colon. 12. Manjunath ND. KN Srinivasa. 2021 injury case. ಯಾರು ಮಿಸ್ಟರ್ ನಾಯ್ಕ್ ಮಂಜುನಾಥ್ ಎಂಡಿ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರ ರೆಗ್ಯುಲರ್ಲಿ? He comes regularly.
Regular.
If we meet him, just inform him there is one case. He doesn't come, otherwise we'll dismiss it. There is no representation on behalf of appellant. Despite several opportunities granted, as last opportunity, list this matter on. Seventeenth. ಅವ್ರಿಗೆ ಬರ್ತಾನೆ ಇಲ್ಲ, 1 ವರ್ಷ ಮೇಲೆ ಆಗಿದೆ.
I am for the appellant, my lord. I am ready, my lord.
ರವಿಶಂಕರ್, ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ರೆಡಿ ಇದ್ರಾ?
ಇಲ್ಲ, ಇದು ಸಾಟರ್ಡೆ ಬಂದಿತ್ತು ಸ್ವಾಮಿ ಅವರ. ಸಾಟರ್ಡೆ ಬಂದಿತ್ತು, 3ಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದೆ ಸ್ವಾಮಿ ಅವರ.
ಯಾರು ರವಿಶಂಕರ್ ಯಾರು?
ಡಿಸ್ಮಿಸಲ್ಗೆ ಹಾಕಿದ್ದೀರಿ ಸ್ವಾಮಿ.
ಹಾ, ಆಲ್ ರೈಟ್. Counsel for appellant present, no representation for R2, call on. 17th.
ಮತ್ತೊಬ್ರು.
Yes. None appears when the case is called. 4:48 PM. Call on. ಯಾರು? ಸುರೇಶ್ ಇಲ್ಲ. ಸುರೇಶ್, counsel for the appellant is present, no representation for R2, call on. Please. Ravi Samprati, Satisha, no representation on either side, call on. Shastri Ji. Same, call on. Same. D Suresh, same, no representation. Guru Prasad, you ready now? ರವಿಶಂಕರ್ ಅವರ ಅಪೋನೆಂಟ್ ಬರ್ಬೇಕು ನಿಮ್ಗೆ.
ಅವರಿಲ್ಲ.
22 ಮ್ಯಾಟರ್, ಡೆತ್ ಕೇಸ್.
ಡೆತ್ ಕೇಸ್ ಲಯಬಿಲಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ವಿ. ಲಯಬಿಲಿಟಿ ಇಸ್ fastened on the owner. This is claimant's appeal. And second point is on the quantum for enhancement also. 2 points I am canvassing.
All right. Learned counsel for the appellant present. None appears for respondent. Call on. Okay.
20th.
20ನೇ ತಾರೀಕು. 19th.
Please.
Gopala Krishna. D. Vijay Kumar. How come nobody is in the VC? All right, same order. None appears. Call on. Same order. Same order. Yes.